Once again, thank you so much, Rex Bookstore and Central Books. Let us introduce our lecturer for today. He graduated magna cum laude with a degree in Bachelor of Arts major in English and History at the Divine Word University. He then obtained his Bachelor of Laws from the University of the Philippines in 1971. He previously served as the Deputy General Counsel of the World Law Association, President of Law Asia Philippines, Chairman of the Integrated Bar of the Philippines Bar Discipline Committee, National President of the Integrated Bar of the Philippines, National President of the Philippine Association of Law Professors Union International de Avocats. He was also a Senior Bar Discipline Commissioner and Supreme Court Accredited Mediator at the RTC and Court of Appeals. He has been in the academe as a professor of various law schools since 1996, including the Far Eastern University College of Law and the Pamantasan ng Lungsod ng Maynila. He is currently the Dean of the Philippine Law School and the Distinguished Lecturer at the MCLE program. He is also the founding partner of J.A. Grapilon Law Office. Let us all welcome Dean José Grapilon. Good afternoon po, Dean.
Good afternoon. Yes, shall we start now?
Yes po, Dean. We can start na po.
Yeah, we're kind of running late, ladies and gentlemen, but we'll try to make maximum use of our time to this afternoon. What I will be lecturing will also include snippets of the new Code of Professional Responsibility and Accountability, and I will compare it with the old one, the CPR. So we start with the most important arsenal in a lawyer's armor, and this is what you call the lawyer's oath. The lawyer's oath, the previous lawyer's oath, has now been revised, and may I, with your permission, read the former lawyer's oath. It says, I, the name, do solemnly swear that I will maintain allegiance to the Republic of the Philippines. I will support the Constitution and obey the laws as well as the legal orders of the duly constituted authorities therein. I will do no falsehood or consent to the doing of any in court, and I will not wittingly or unwittingly promote or sue any groundless, false, or unlawful suit, or give aid or consent to the same. I will delay no man for money or malice, and will conduct myself as a lawyer according to the best of my knowledge and discretion with all good fidelity, as well as upon myself, as well as to my clients. And I impose upon myself these voluntary obligations without my mental reservations or purpose of evasion, so help me God. In the revised lawyer's oath, it says, and it virtually actually revised some important aspects of the old lawyer's oath. And I, with your permission, read. I, the name, do solemnly swear that I accept the honor, privilege, duty, and responsibility of practicing law in the Philippines as an officer of the court in the interest of the people. I declare fealty to the Constitution of the Republic of the Philippines. In so doing, I shall work towards promoting the rule of law and a regime of truth, justice, freedom, love, equality, and peace. I shall conscientiously and courageously work for justice, as well as safeguard the rights and meaningful freedoms of all persons, identities, and communities. I shall ensure greater and equitable access to justice, and I shall do no falsehood, nor shall I pervert the law to unjustly favor or nor prejudice anyone. I shall faithfully discharge the duties and responsibilities to the best of my ability with integrity and utmost civility. I impose upon this upon myself without mental reservation or purpose of evasion. Here, there's a nod to the secular aspect of our beliefs because it says that you are given the discretion to either take an oath saying, "So help me God," or you just omit the oath by affirmation. So this year's bar passers will be sworn under the new lawyer's oath. The lawyer's oath binds all lawyers as a source of obligation such that it is a violation, its violation is a ground for suspension, disbarment, or disciplinary action. A member of the bar may be penalized, even disbarred, or suspended from his office as an attorney for violating the lawyer's oath and or for breaching the ethics of the profession, a form of public trust, the performance of which is entrusted to those who are qualified and who possess good moral character, and the appropriate penalty on an errant lawyer depends on the exercise of sound judicial discretion based on the surrounding facts. Penned by Justice Hernando, February 10, 2021, Constantino versus Aranzazo Jr. Constantino versus Aranzazo Jr. AC number 9701. Disciplinary proceedings against lawyers are designed to ensure that whoever is granted the privilege to practice law in the country shall remain faithful to the lawyer's oath. Again, on July 2, 2018, in the case of Jimeno Jr. versus Jimeno, administrative case number 12012, July 2, 2018. What then is the practice of law? Before the amendment of the Code of Professional Responsibility, jurisprudence defines the practice of law as any activity in or out of court which requires the application of law, legal procedure, knowledge, training, and experience. To engage in the practice of law is to perform these acts which are characteristics of the profession. Generally, to practice law is to give notice or render any kind of service which device or service requires the use in any degree of legal knowledge or skill. Case of the landmark case of Cayetano versus Monson, 278 Philippines 235 to 274, 1991. Notably, under the old CPR, the practice of law is not limited to the conduct of cases in court. Under Section 1, Canon 3 of the new Code of Professional Responsibility and Accountability, which took effect on May 29, 2023, and is retroactive in nature, the term practice of law is defined as follows. Section 1, practice of law. The practice of law is the rendition of legal service or performance of acts or the application of law, legal principles, and judgment in and out of court with regard to the circumstances or objectives of a person or a cause, or other engagement governed by the Code of Professional Responsibility and Accountability. It includes employment in the public service or private sector and requires membership in the Philippine Bar as qualification. I must apologize that I cannot give you still or share the slides I'm presenting to you now because I'm trying to get the permission of my co-author of this lecture, and I'm sure by September 4, before that, I will be giving you already a copy of this, and after I get the consent of my partner in this endeavor. Generally, under the old CPR, to practice law is to give advice or render any kind of service that involves legal knowledge or skill. The practice of law is not limited to the conduct of cases in court. It includes legal advice and counsel and the preparation of legal instruments and contracts by which legal rights are secured although such matter may or may not be pending in court. Ulip versus Legal Clinic Incorporated, 295 Philippines 295-492, 1993. I was involved in this particular case because I was then the National Executive Director of the IBP, and we brought a petition to the Supreme Court questioning precisely why this particular firm was designating itself as legal clinic instead of identifying the partners in that firm, which under our Philippine jurisdiction, usually you have to identify these persons involved in the firm. In turn, under the the CIPRA, it defines a lawyer-client relationship in this wise. Section 3. A lawyer-client relationship is of the highest fiduciary character. As a trust relation, it is essential that the engagement is founded on the confidence reposed by the client on the lawyer. Therefore, a lawyer-client relationship shall arise when the client consciously, voluntarily, and in good faith vests a lawyer with the client's confidence for the purpose of rendering legal service, and the lawyer, whether expressly or impliedly, agrees to render such legal services. Emphasis is on agreement to render legal services. On the other hand, in Constantino versus Aranzazo Jr., which I mentioned earlier, the moment the client seeks the lawyer's advice upon a legal concern, that starts the lawyer-client relationship, seeking maybe for consultation on transactions or other legal concerns, or for representation of the client in an actual case in the courts or other fora. From the moment on, the lawyer is bound to respect the relationship and to maintain the trust and confidence of the client. What are the factors used to determine if one is engaging in the practice of law? The factors determinative of whether a particular activity constitutes practice of law are as follows. 1, habituality. 2, compensation. 3, application of law, legal principles, practice or procedure, and attorney-client relationship, still emphasized in Cayetano versus Monson. The practice of law is not a right but a privilege bestowed by the state only on those who possess and continue to possess the qualifications required by law for the conferment of such privilege. The privilege may be taken away if one falls short of the requirements imposed by law. The case of AA Total Learning Center for Young Achievers Incorporated versus Caronan, penned by Justice Hernando in administrative case number 12418, March 10, 2020. The title of attorney is reserved to those who, having obtained the necessary degree in the study of law and successfully taken the bar examinations, have been admitted to the Integrated Bar of the Philippines and remain members thereof in good standing. And it is they only who are authorized to practice law in this jurisdiction. The practice of law is a privilege burdened with conditions and is reserved only for those who meet the twin standards of legal proficiency and morality. It is so delicately imbued with public interest that it is both a power and a duty of this court to control and regulate it in order to protect and promote the public welfare. Again, penned by Justice Hernando on October 16, 2019, the case of Pitelo versus Rivera, administrative case number 10408. 10408. In Pitelo versus Rivera, the respondent lawyer that handled the case was admonished that the practice of law is not a natural, absolute, or constitutional right to be granted to anyone or everyone who demands it. It is a high personal privilege limited to citizens of good moral character with special educational qualifications duly ascertained and certified. Being thus a personal privilege, respondent cannot simply consent to anyone issuing his signature, using his signature and other bar details. He did not have the authority to bestow license to anybody to practice law because by doing so, he usurped the right and authority that is exclusively vested upon this court. The authority to allow somebody to, or any law practitioners, to practice law and scrutinize the fitness and qualifications of any law practitioner remains with the court. And respondent has no right whatsoever to exercise the nature of a privilege or franchise. It is limited to persons of good moral character with special qualifications duly ascertained and certified. The right does not only presuppose in its possessor integrity, legal standing, and attainment, but also the exercise of a special privilege, highly personal and partaking of the nature of public trust. Under the CIPRA, Section 35 tells us that the non-delegable tasks include a lawyer shall not delegate to or permit a non-lawyer, including a paralegal, to assign cases on behalf of the lawyer or sign cases on behalf of the lawyer or give a lawyer's opinion or without the lawyer's supervision or direction, give advice to certain clients and be named in association with a lawyer in any pleading or submission to any court, tribunal, or government agency. Under letter E, that the lawyer in any tribunal or government agency should not actively participate in formal legal proceedings on behalf of the client except when allowed by law or rules. Also, the non-delegable task includes that lawyer cannot bind third parties unless allowed in administrative agencies without the lawyer's supervision or direction. These provisions shall not apply to law student practitioners under Rule 138-A of the Rules of Court. In BHAG versus ERA, administrative case number 12880, November 23, 2021, Attorney ERA exercised deceit and betrayed his fiduciary duty towards his client when he took advantage of his superior knowledge of the law and filed two actions on behalf of Laneco when only one would have sufficed. As may be readily gleaned from his fee structure, he charged separate engagement fees, appearance fees, and pre-success and success fees for each of the two cases. Obviously, his intention was to turn the engagement contract into a money-making venture. The principle that law advocacy is not capital that necessarily yields profits has been totally lost on him, emphasizing that the law is a profession and not a business or trade. Section 27, Rule 138 of the Rules of Court expressly provides that the practice of soliciting cases at law for purposes of gain, either personally or through paid agents or brokers, constitutes malpractice. In Director of Religious Affairs versus Bayo, the court, speaking through Justice Osaeta, declared that it is highly unethical for an attorney to advertise his talents or skills as a merchant advertises his wares. Law is a profession and not a trade. The lawyer degrades himself and his profession who stoops to and adopts the practice of mercantilization by advertising the services, offering them to the public. As a member of the bar, he defiles the temple of justice with mercenary activities as the money changers of old defiled the temple of Jehovah. The most worthy and effective advertisement possible, even for a young lawyer, is the establishment of a merited reputation for professional capacity and fidelity to the trust. This cannot be forced, but must be the outcome necessarily of character and conduct. Citing in Rita Gorda, where the respondent lawyer was suspended from the practice of law for 1 month for advertising his services and soliciting work from the public by writing circular letters. The court reprimanded Attorney Bayot for having published an advertisement in the Sunday Tribune on June 30, 1943, which offers his legal assistance in securing marriage licenses. In the previous CPR, Rule 2.03 says that a lawyer should not and do not or permit to be done any act designed primarily to the advantage of another person. Rule 204 says that a lawyer shall not charge rates lower than those customarily prescribed unless the circumstances so warrant. Rule 3.04 says that the lawyer should not charge anything of value to the representative of his client in anticipation of or in return for a job. Under the new CIPRA, Canon 2 on propriety talks about Section 17, where it says non-solicitation and impermissible advertisement. A lawyer shall not directly or indirectly solicit or appear to the public as one who is soliciting cases. A lawyer shall not directly or indirectly advertise legal services on any platform or media except with the use of dignified, verifiable, and factual information, including biographical data, contact details, fields of practice, services offered, and the like, so as to allow a potential client to make an informed choice. In no case shall the permissible advertisement be self-laudatory. A lawyer, law firm, or any of its representatives shall not receive any benefit or consideration or any award-giving body, professional organization, or personally in anticipation of or in return of the award or recognition, service, or retainers. Unethical acts of borrowing money from the client and accepting payment but not performing any work. Time and again, the court has consistently held that deliberate failure to pay just debts constitutes gross misconduct for which a lawyer may be sanctioned with suspension from the practice of law. Lawyers are instruments for the administration of justice and vanguards of our legal system. They are expected to maintain not only legal proficiency, but also a high standard of morality, honesty, integrity, and fair dealing, so that the people's faith and confidence in the judicial system is ensured. They must at all times faithfully perform their duties to society, to the bar, the courts, and their clients, which include prompt payment of financial obligations, as enunciated in Foster versus Antang, 749 Philippines, 576 to 598, 2014. In Buenaventura versus Gill, the court disbarred the respondent for borrowing money from his client, for presenting a spurious title of mortgage property, for refusing to pay his debt despite demand, for issuing a worthless check and failing to comply with the orders of the Integrated Bar of the Philippines. In Reyes Jr. versus Rivera, the court likewise disbarred the respondent therein for misappropriating the funds of his client and misrepresenting that he filed a petition for declaration of nullity of marriage before the RTC when none was in fact filed. Respondent even simulated the stamp of the office of the clerk of court of the RTC to make it appear that it received the petition. In Brunet versus Guared, Respondent is Guaran. Respondent lawyer, despite having received a portion of his acceptance fee, neglected and failed to perform his obligation to file the case for titling of complainant's lot. Consequently, the court found him guilty of violating the Code of Professional Responsibility, especially Canon 17, fidelity to the cause of his client, and 18, competence and diligence, and suspended him for a period of 6 months. In so ruling, the court stressed that the practice of law is not a business. It is a profession in which the duty to public service, not money, is the primary consideration. Lawyering is not primarily meant to be a money-making venture, and law advocacy is not capital that necessarily yields profits. The gaining of a livelihood should be a secondary consideration. The duty to public service and to the administration of justice should be the primary concern of lawyers, and who must subordinate their personal interest on what they owe to themselves. How is the legal profession distinguished from a mere business? In Res Sisip Salazar Feliciano Hernandez and Castillo, GR number X92-1, July 30, 1979, the court found time to make this observation. The following are the characteristics which distinguishes the legal profession from a mere business. Namely, first, a duty of public service of which the emolument is a byproduct and in which one may maintain the highest eminence without making much money. Second, a relation as an officer of the court to the administration of justice involving thorough sincerity, integrity, and reliability. And third, a relation to clients in the highest degree, fiduciary. And fourth, a relation to colleagues at the bar characterized by candor, fairness, and unwillingness to resort to current business methods of advertising and encroachment on the practice or dealing directly with the clients. What then are requirements for admission to the bar? The rules of court mandates that the applicant for admission to the bar must be a citizen of the Philippines, at least 21 years of age, of good moral character, and a resident of the Philippines. He must also produce before this court satisfactory evidence of good moral character, and that no charges against him involving moral turpitude have been filed or pending in any court in the Philippines. Moreover, admission to the bar involves various phases, and such as furnishing satisfactory proof of educational, moral, and other qualifications, passing the bar examinations, taking the lawyer's oath, and signing on the roll of attorneys, and receiving from the clerk of court a certificate of the license to practice. This was in Reda Canay 565 Philippines, 165 to 171 2007. Every applicant for admission as a member of the bar must be a citizen of the Philippines, resident, produce satisfactory evidence of good moral character, at least 21 years of age, no charges involving moral turpitude filed or pending, and lawyer's oath. Must pass the bar examination, complied with the academic requirements under the law, earned a bachelor's degree in arts or science, pre-law, and completed all the prescribed courses for the degree of Bachelor of Laws or its equivalent degree, the law course. Now it's called the Juris Doctor, and must sign the roll of attorneys. Under Administrative Matter number 19-03-23-SC and re-amendment to Section 5, Rule 138 in relation to the revision of Rule 138-A of the Rules of Court, no applicant who obtained the Bachelor of Laws degree shall be admitted to the bar examination unless he or she has satisfactorily completed the following course in a law school or university duly recognized by the government. It includes civil law, commercial law, remedial law, criminal law, public and private international law, political law, labor and social legislation, medical jurisprudence, taxation, legal ethics, and clinical legal education program. Rule 7.02 says that the lawyer shall not support the application for admission to the bar of any person known by him to be unqualified in respect to character, education, or relevant attribute. Rule 7.01 says that a lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for admission to the bar. Who are then citizens of the Philippines? A reiteration of what we have studied in citizenship. And may I read? Under Section 1, Article 4 of the 1987 Constitution, the following are citizens of the Philippines. Number 1, those who are citizens of the Philippines at the time of the adoption of this Constitution. Number 2, those whose fathers or mothers are citizens of the Philippines. Number 3, those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. And number 4, those who are naturalized in accordance with law. The question is, can a Filipino citizen who graduated from a foreign law school be admitted to the Philippine bar? The answer is that a Filipino citizen who graduated from a foreign law school shall be admitted to the bar examination only upon submission to the Supreme Court of certification showing 1, the completion of all courses leading to the degree of Bachelor of Laws or its equivalent degree. Number 2, recognition or accreditation of the law school by the proper authority. Number 3, completion of all fourth-year subjects in the Bachelor of Laws academic program in a law school duly recognized by the Philippine government. This refers to bar matter number 1153. Can a lawyer who loses his Philippine citizenship continue to engage in the practice of law in the Philippines? The Constitution provides that the practice of all professions in the Philippines shall be limited to Filipino citizens, save in cases prescribed by law. Since Filipino citizenship is a requirement for admission to the bar, the loss thereof terminates membership in the Philippine bar and consequently the privilege to engage in the practice of law in the Philippines. In other words, the loss of Filipino citizenship ipso iure terminates the privilege to practice law in the Philippines. The practice of law is a privilege denied to foreigners. The exception is when Filipino citizenship is lost by reason of naturalization as a citizen of another country, but subsequently reacquired pursuant to Republic Act 9225 or the Citizenship Retention and Reentry and the Acquisition Act of 2003. This is because, quote, all Philippine citizens who become citizens of another country shall be deemed not to have lost their Philippine citizenship under the conditions of Republic Act 9225, close quote. Therefore, a Filipino lawyer who becomes a citizen of another country is deemed never to have lost his Philippine citizenship if he reacquires it in accordance with Republic Act 9225. Although he is also deemed never to have terminated his membership in the Philippine bar, no automatic right to resume law practice accrues. Again, this is in Reda Kanay 565, Philippines, pages 165 to 171, in 2007. What are the conditions before a lawyer who reacquires his citizenship under Republic Act 9225 can resume his practice of law? Again, in Rede Canay, the court says that the lawyer who reacquires his Philippine citizenship based on Republic Act 9225 can resume his law practice by securing from the Supreme Court the authority to do so conditioned on the following. Number one, the updating and payment in full the annual membership dues in the IBP. Number two, the payment of the professional tax. Number three, the completion of at least 36 credit hours of mandatory continuing legal education. This is especially significant to refresh the applicant petitioner's knowledge of Philippine laws and update him of legal developments. And number four, retaking of the lawyer's oath, which will not only remind him of his duties and responsibilities as a lawyer and as an officer of the court, but also renew his pledge to maintain allegiance to the Republic of the Philippines. What are the continuing requirements for membership in the bar? The following are the continuing requirements for membership in the bar. Number one is the citizenship requirement, Section 14, subsection 2, Article 12 of the 1987 Constitution. Number two is the possession of good moral character. The possession of good moral character is both a condition precedent and a continuing requirement to warrant admission to the bar and to retain membership in the legal profession. This proceeds from the lawyer's duty to observe the highest degree of morality and good order to safeguard the bar's integrity. The case of Bautista versus Ferrer, administrative case number 9057, July 3, 2019. Good moral character has been defined as including at least common honesty. It has also been held that no moral qualification for bar membership is more important than truthfulness or candor, exemplified in the case of Tan versus E.L. Sabandal, 283 Philippines, pages 390 to 400, 1992. Membership in the Integrated Bar of the Philippines is also a continuing requirement in good standing and the payment of IBP dues as defined in Rule 138 of the Rules of Court, Section 1, and Article 3 of the IBP bylaws. Under Section 10, Rule 139-A, the default in the payment of annual dues for 6 months shall warrant suspension of membership in the Integrated Bar, and default in such payment for 1 year shall be a ground for the removal of the name of the delinquent member from the roll of attorneys. Number four, compliance with the mandatory continuing legal education requirements and the payment of the professional tax. What is membership in good standing? The second requisite for the practice of law, membership in good standing, is a continuing requirement. This means continued membership, and concomitantly payment of annual membership dues in the IBP, payment of the annual professional tax, compliance with the mandatory continuing legal education requirement, faithful observance of the rules and ethics of the legal profession, being continually subject to judicial disciplinary control. What is the purpose of requirement of good moral character? In Dantes versus Dantes, 482 Philippines 64-272, 2004, Court observed and said that it should be noted that the requirement of good moral character has four ostensible purposes, namely, one, to protect the public. Number two, to protect the public image of lawyers. Number three, to protect prospective clients. And number four, to protect errant lawyers from themselves. To protect errant lawyers from themselves. A lot of lawyers, law students, and common people confuse certain aspects of what is the meaning of moral turpitude. In De Jesus Paras versus Bailoses, 111 Philippines, 569 to 572, 1961, the Supreme Court defined moral turpitude by saying that it is an act of baseness, vileness, or depravity in the private and social duties which a man owes his fellow men or to society in general, contrary to the accepted standards and customary rule of right and duty between man and man, or conduct contrary to justice, modesty, honesty, or good morals. Examples of crimes involving moral turpitude are as follows. Number one, estafa, because the act is unquestionably against justice, honesty, and good morals. Number two, violation of BP 22, as the issuance of worthless checks indicates a lack of personal honesty and good moral character. Number three, falsification. Number four, embezzlement, forgery, robbery, and swindling are crimes which denote moral turpitude. And as a general rule, all crimes of which fraud is an element are looked on as involving moral turpitude. Under Section 27, Rule 138 of the Rules of Court, a lawyer may be removed or suspended on the ground, among others, by conviction of a crime involving moral turpitude. In Soriano versus Dizon, 515 Philippines, 635 to 647, 2006, conviction for a crime involving moral turpitude may relate and not to the exercise of the profession of lawyers, but certainly to the good moral character, where their misconduct outside of their professional dealings is so gross as to show them morally unfit for their office and unworthy of the privileges conferred upon them by their license, the court may be justified in suspending or removing them from that office. International Rights Research Institute versus National Labor Relations Commission, GR number 97239, May 12, 1993, defined or answered the question of, does the crime of homicide involve moral turpitude? It's a very interesting Supreme Court ruling, and I may read. Homicide may or may not involve moral turpitude depending on the degree of the crime. Moral turpitude is not involved in every criminal act and is not shown by every known and intentional violation of statute. But whether any particular conviction involves moral turpitude may be a question of fact and frequently depends on all the surrounding circumstances. While generally, but not always, crimes mala in se involve moral turpitude, while crimes mala prohibita does not, it cannot always be ascertained whether moral turpitude does or does not exist by classifying a crime as malum in se or as malum prohibitum, since there are crimes which are mala in se and yet, but rarely involve moral turpitude. And there are crimes which involve moral turpitude and are mala prohibita only. It follows, therefore, that moral turpitude is somewhat a vague and indefinite term, the meaning of which must be left to the process of judicial inclusion or exclusion as the cases are reached. What happens if the applicant deliberately fails to disclose that there are pending criminal cases against him or her? Under Rule 7.01 of the CPR, it says that the lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for admission to the bar. In Reharon versus Meling, BM number 1154, June 8, 2004, respondents' non-filing, non-disclosure of the criminal cases filed against him makes him also answerable under Rule 701 of the Code of Professional Responsibility, which states that, quote, a lawyer shall be answerable for knowingly making the false statement or suppressing a material fact in connection with his application for admission to the bar, close quote. The judiciary has no place for dishonest officers of the court. The solemn task of administering justice demands that those who are privileged to be part of service therein, from the highest official to the lowliest employee, must not only be competent and dedicated, but also must live and practice the virtues of honesty and integrity. Anything short of this standard will diminish the public's faith in the judiciary and constitute infidelity to the constitutional tenet that the public office is a public trust. Similarly, the declaration in the application for the bar exams that he was single was a gross misrepresentation of a material fact in utter bad faith and violation of Rule 7.01. That false statement, if it had been known, would have disqualified him outright from taking the bar examination, as it indubitably exhibits lack of good moral character. Under Section 1, Rule 138 of the Rules of Court, it says that any person heretofore duly admitted as a member of the bar or thereafter admitted as such in accordance with the provisions of this rule, Rule 138, and who is in good and regular standing is entitled to practice law. Pursuant thereto, any person admitted as a member of the Philippine Bar in accordance with the statutory requirements and who is in good and regular standing is entitled to practice law. Can non-lawyers appear before the court? In SETA versus Malinaw, 176 Philippines 619 to 624, 1978, as a rule, only members of the bar are allowed to practice. To recall, we mentioned Pitello versus Rivera. The court stressed that the practice of law is a personal privilege. A lawyer does not have the authority to bestow license to anybody to practice law, because by doing so, he usurps the right and authority that is exclusively vested upon this court. Enumerated below are the exceptions, instances where non-lawyers may appear before the court. Number one is the law student practice rule. Pursuant to Rule 138-A of the Rules of Court, law students duly certified therein can engage in the practice of law in a limited capacity. The limited practice of law covers appearances, drafting and submission of pleadings and documents before trial, and appellate courts and quasi-judicial and administrative bodies, assistance in mediation and other alternative modes of dispute resolution, legal counseling, and advice, and such other activities that may be covered by the clinical legal education program of the law school. Reference is made to Administrative Matter number 19-03-24-SC, June 25, 2009, Section 1, Rule 138-A, Law Student Practice. What are the practice areas of law student practitioners? For Level 1 certification, as distinguished from Level 2 certification, these are the requirements. It provides legal and Level 1 certification. You provide public legal orientation. You assist in public interest advocacies for policy formulation and implementation. You give legal advice to the client and represent eligible parties before quasi-judicial or administrative bodies. For Level 2 certification, you have to perform all activities under Level 1 certification. You have to assist in the taking of depositions and or preparing judicial affidavits of witnesses and appear on behalf of the client at any stage of the proceedings or trial before any court, quasi-judicial or administrative bodies. What are the respective duties of the law student practitioners, their supervising lawyers, as well as the law schools? The duties of the law student practitioners to be acting under a certification, and the law student practitioner shall observe the provisions of Section 24, subsection B, Rule 130 of the Rules of Court. The duty of the law school through the dean or authorized representative must develop and adopt a clinical legal education program. The duty of supervising lawyers are supervise such number of certified law student practitioners as far as practicable, and personally appear with the law student practitioner in all cases pending before the second level courts, and in all other cases the supervising lawyer determines that his or her personal presence is required. Among the duties also of the law student practitioner is to be prohibited from using information acquired in one's capacity as a law student practitioner for personal or commercial gain. Among others, the law student practitioner must perform the duties and responsibilities to the best of one's ability as a law student practitioner, and to strictly observe the canons of the CIPRA, the new canons of professional responsibility and accountability. For the law schools, continuing, it must develop and establish at least one law clinic in the school. It must endorse qualified students for certification as law student practitioners under this rule. Such certification or endorsement shall constitute as a certification that the dean or authorized representative knows that the applicant is a student enrolled in the clinical legal education course, possesses good moral character, and has met the requirements of Section 3 of the rule, and must ensure compliance by the law student practitioners and supervising lawyers with the CPRA. On the part of duties of the supervising lawyer, among others, it includes assuming personal professional responsibility for any work performed by the certified law student practitioner while under his or her supervision. Among others, the supervising lawyer must assist and advise the certified law student practitioner in the activities authorized by these rules and review such activities with the certified law student practitioner, all to the extent required for the proper practical training of the certified law student practitioner and the protection of the client. Also, the supervising lawyer must read, approve, and personally sign any pleadings, briefs, and other similar documents prepared by the certified law student practitioner prior to the filing thereof, and read and approve any documents which shall be prepared by the certified law student practitioner for execution by the eligible party, and lastly, provide the level of supervision to the certified law student required by these rules. Who are the persons authorized to appear for the government? In Villa Gomez versus People, GR number 216824, November 10, 2020. Under Section 33, Rule 138 of the Rules of Court, any official or other person appointed or designated in accordance with law to appear for the government of the Philippines shall have all the rights of a duly authorized member of the bar to appear in any case in which said government has an interest, direct or indirect. This means that jury authorized officials, even if they are not members of the bar, have the authority to sue on behalf of and bind their principals to the judgment or any disposition of a competent court in the same manner and capacity as those who are actual members of the bar. Such category of legal representation is part of the performance of official acts as mandated by law. Pro se or personal appearance. In civil cases before the Metropolitan Trial Court, a party may conduct its litigation in person with the aid of an agent or a friend appointed by him for the purpose. Any court, that is, the RTC, any party may conduct his litigation personally or by aid of an attorney, and his appearance must be either personal or by a duly authorized member of the bar under Section 34, Rule 138. Notably, a non-lawyer conducting his own litigation is bound by the same rules in conducting the trial of his case. He cannot, after judgment, claim that he was not properly represented. In places where there are no available lawyers, Section 7, Rule 16 says that in criminal cases, the rule is that an accused has an immutable right to be assisted by a member of the bar. It is a due process requirement, and thus, even if the judgment has become final and executory, it may still be recalled, and the accused afforded the opportunity to be heard by himself and counsel. The case of spouses Telan versus Court of Appeals, 279, Philippines 587 to 596, 1991. However, in localities where such members of the bar are not available, the court may appoint any person, resident of the province and of good repute for probity and ability to defend the accused. Section 7 of Rule 116. In administrative and quasi-judicial bodies, when expressly allowed by law, under Section 2, Rule 8, Resolution number 38 series of 2006, in the Energy Regulatory Commission's Rules of Practice and Procedure, a party may represent himself or may be represented by an attorney. Any non-lawyer who satisfies the commission or the presiding officer that he or she possesses the expertise to render valuable service to a party and assist it in the presentation of matters before the commission may be allowed to appear on behalf of a party or parties. The commission, referring to the Energy Regulatory Commission, may also direct the appearance of the Grid Management Committee, Distribution Management Committee, or some other experts as interveners in certain cases where, in the determination of the commission, they may be of assistance to the commission in the resolution of matters brought before it. Section 11, Rule 3 of the 2019 Revised Rules of Procedure of the HLURB provides that the appearance of counsel or representative is optional. And under Section 11 of the same rule, a non-lawyer who represents a party shall attach to the pleading and special power of attorney, authorizing such person to file the case and an affidavit duly executed by the party represented, stating the reasons why such person was so authorized. In labor cases, a non-lawyer may appear subject to certain conditions. Under Section 6, Subsection B, Rule 3 of the NLRC Rules of Procedure, a non-lawyer may appear in any of the proceedings before the labor arbiter or commission only under the following conditions. Number 1, that he or she represents himself or herself as a party to the case. Number 2, he or she represents a legitimate labor organization which is a party to the case. Number 3, he or she represents a member or members of a legitimate labor organization that is existing within the employer's establishment who are parties to the case. Number 4, he or she is a duly accredited member of the legal aid office recognized by the Department of Justice or Integrated Bar of the Philippines. And number 5, that he or she is the owner or president for any other authorized person of a corporation or establishment which is a party to the case. A non-lawyer may represent the claimant before the cadastral court. Section 9 of Act number 2259 of the Cadastral Act provides that any person claiming any interest in any part of the lands, whether named in the notice or not, shall appear before the court by himself or by some person in his behalf. And he shall file an answer on or before the return day or within such further time as may be allowed by the court, and the answer shall be signed and sworn to by the claimant or by some person in his behalf, and shall state whether the claimant is married or unmarried, and if married, the name of the husband or wife and the date of the marriage. What are the limitations on the appearance of non-lawyers before courts? Non-lawyers shall confine his or her work to non-adversarial contentions. In this case, he should not undertake purely legal work, such as examination or cross-examination of witnesses or the presentation of evidence. This is in Robinson versus Villafuerte Iraniola, 18 Philippines, pages 171 to 193, 1911. Number 2 limitation is the services of non-lawyers should not be habitually rendered, since the calling constitutes the practice of law which is reserved for members of the bar. And number 3, non-lawyers cannot collect attorney's fees. In the case of the Philippine Association of Free Labor Unions versus Binalbagan Sugar, Isabela Sugar Company, 149 Philippines, pages 401 to 409, 1971, the court went on to say that the permission for a non-member of the bar to represent or appear or defend in any court on behalf of the party litigant does not by itself entitle the representative to compensation for such representation. The rules of court under section 24, rule 138 says that an attorney shall be entitled to have and recover from his client no more than a reasonable compensation for his services. Such a relationship cannot exist unless the client's representative in court be a lawyer, and since respondent Moning is not one, he cannot establish an attorney-client relationship with Enrique Antila and Victoria or with Paflu, and he cannot therefore recover attorney's fees. Rule 9.02 of the CPR states, a lawyer shall not divide or stipulate to divide a fee for legal services with persons not licensed to practice law, except where there is an agreement with a partner or associate that upon the latter's death, money shall be paid to his estate or persons specified in the agreement, and that where the law undertakes that the deceased lawyer is given such privilege, or where the lawyer or law firm includes non-lawyer employees in a retirement plan, even if the plan is based in whole or in part on the dividends earned by the law firm. Similar, under section 334, subsection O of the CIPRA, the unauthorized division of fees with a non-lawyer is a less serious offense, which is by suspension from the practice of law for a period within the range of 1 month to 6 months, and or a fine within the range of 35,000 to 100,000. Unless the foregoing limitations are observed, the legality of the appearance of a layman as permitted by law may be seriously doubted, and he or she may be held liable for unauthorized practice of law. We have to note that the legal remedies to suppress the unauthorized practice of law includes petitions for injunction, declaratory relief, contempt of court, petition for disqualifications, complaints for disbarment or administrative complaints against the erring lawyer or public official. A criminal complaint for estafa may also be filed against a person who pretended to be an attorney to the damage of a party. In what proceedings are lawyers not allowed to appear? Under Section 415 of Republic Act 7160, the Local Government Code of 1991, the parties must appear in person without assistance of counsel, and the appearance of parties in person in all the parties must appear in person without the assistance of counsel or representative, except for minors and incompetents who must be assisted by their next of kin who are not lawyers in all katarungang pambarangay proceedings. Under Section 10, subsection C, Rule 4, pleadings, practice, and procedure before the National Commission on Indigenous People in disputes involving indigenous cultural communities, indigenous peoples, the general rule is that lawyers are prohibited to appear for any party as counsel. However, as an exception, lawyers may appear provided that he or she is appearing in his or his capacity as a member of a council of elders or due to his obligation as a member of the indigenous people's community or for the purpose of defending or prosecuting his or her case. In the first level courts, provides that no attorney shall appear in behalf of or represent a party at the hearing unless the attorney is a plaintiff or defendant. If the court determines that the party cannot properly present his or her claim or defense and needs assistance, the court may, in its discretion, allow another individual who is not an attorney to assist the party upon the latter's consent. Are there instances when a lawyer is not allowed to practice law? Are there instances when the lawyer is not allowed to practice law? Suspended lawyers during the period of suspension and before the lifting of the suspension on the guidelines for the lifting of the order of suspension in the case of Tan Jr. versus Gumba, administrative case number 9000, January 10, 2018. Justice Hernando had the occasion to be the ponente in Cancino versus Cedariosa, administrative case number 8522, October 6, 2020. And he said that engaging in the practice of law during one suspension is a clear disrespect to the orders of the court. In so doing, the faith and confidence which the public has reposed upon the judicial system has been put at stake, as it gives the impression that the court's order is nothing but a mere scrap of paper with no teeth to bind the parties and the whole world. Number 2, lawyers, public officials who by express provision of law are prohibited from engaging in the practice of any profession during their tenure. Number 1, the president, the vice president, cabinet members, and their deputies. Section 13, Article 7 of our Constitution prohibits the president, the vice president, members of the cabinet, and their deputies or assistants from directly or indirectly practicing any other profession during their tenure. Number 2, governors and mayors. Under Section 90 of Republic Act 7160, all governors, city and municipal mayors are prohibited from practicing their profession or engaging in any occupation other than the exercise of their functions as local chief executives. Number 3, judges and officials or employees of superior courts. Number 4, the Solicitor General, Assistant Solicitor General, State Solicitors, Associate Solicitors, and other officials, employees of the OSG. Rule 138, Section 35 prohibits judges and officials, employees of superior courts, or the office of the Solicitor General from engaging in the private practice or giving professional advice to clients. And in Section 35, it specifically states that no judge or other official or employee of the Superior Courts of the Office of the Solicitor General shall engage in private practice as a member of the bar or give professional advice to clients. Number 5, members of the Judicial and Bar Council. Number 6, government prosecutors, except the isolated appearance of a private prosecutor, for a case where the offended party is his relative authorized by his superior. It will not violate the rule which bars certain attorneys from practicing law. People versus Villanueva, 121, Philippines, pages 894 to 898, 1965. Next prohibition is the ombudsman and his deputies. Under Section 8, Paragraph 2 of the Article 11 of the Constitution, the ombudsman and his deputies shall not engage in the practice of any profession. Chairpersons, and members of the Constitutional Commission cannot practice any profession during his or her tenure. And other prohibitions based on special law. For example, under Section 7B of Republic Act 6743 prohibits public officials and employees during their incumbency from engaging in the private practice of their profession unless authorized by the Constitution or law, provided that such practice will not conflict or tend to conflict with their official functions. That is, in the case of Noriega versus Season, 210 Philippines, 236 to 243, respondent SEC hearing officer was charged with malpractice for allegedly violating the prohibition of government employees to practice their profession. Nonetheless, the court dismissed the disbarment complaint after finding the respondent's appearance is an isolated case. Hence, it does not constitute the practice of law more so since respondent did not derive any pecuniary gain or benefit from his appearance because respondent and defendant were close family friends. One other prohibition is for civil service officers or employees whose duties require them to devote their entire time at the disposal of the government. Catu versus Rellosa, 569 Philippines, 539 to 551, 2008. Lawyers or public officials with restrictions to practice law. Civil service officers or employees whose duty does not require the entire time to be at the disposal of the government with written personal permission from the respective department heads. Lawyers who are senators or members of the House of Representatives are only prohibited from appearing as counsel before any court of justice or before electoral tribunals or quasi-judicial or other administrative bodies. Sangguniang members under the local government code may practice their profession, engage in any occupation, or teach in schools, except during session hours, provided that Sangguniang members who are also members of the bar shall not appear as counsel before any court in any civil case where the local government unit or any office, agency, or instrumentality of the government is the adverse party. Sangguniang Bayan members may appear as counsel in any criminal case wherein an officer or employee of the national or local government is accused of an offense committed in relation to his office cannot appear. They cannot collect any fee for their appearance in administrative proceedings involving the government unit of which he is an official, and cannot use property and personnel of the government except when the Sangguniang member concerned is defending the interest of the government. Retired judges or justices under Section 1 of Republic Act 910 as amended by 9946. One of the conditions of their pension for retired justices or judges is that, quote, no retiring justice or judge of the aforementioned courts or his or her surviving spouse receiving the benefits of this act during the time that he or she receiving said pension shall appear as counsel before any court in any civil case wherein the government or any subdivision or instrumentality thereof is the adverse party, or in any criminal case wherein an incumbent or former officer or employee of the government is accused of an offense committed in relation to his or his office, or collect any fee for his appearance, and in any administrative proceedings to maintain an interest to the government, national, provincial, or municipal, or to any of the legally constituted offices. Former government lawyers. Adverse interest conflicts exist when the matter in which the former government lawyer represents a client in private practice and is substantially related to a matter that the lawyer dealt with while employed by the government, and the interests of the current and former are adverse. On the other hand, you have what you call congruent interest. Representation conflicts are unique to government lawyers and apply primarily to former government lawyers. In PCGG versus Sandigan Bayan, incongruent interest representation conflict, disqualification does not really involve conflict at all. Lawyers authorized to represent the government. The following are the persons authorized to represent the government. Number one, the Solicitor General, Assistant Solicitor General, State Solicitors, and Trial Attorneys. Number two, State Prosecutors or Special Counsels in the Department of Justice. Number three, Provincial and City Prosecutors and their assistants and their attorneys in other legal offices of the government. Number four, any person appointed or designated in accordance with law to appear for the government of the Philippines, who shall have all the rights of a duly authorized member of the bar to appear in any case in which said government has or an interest, direct or indirect. What are the differences now between the rule on government lawyers as defined under the previous CPR and now under the CIPRA? Canon 6 of the CPR says that this canon shall apply to lawyers in government services in the discharge of their tasks. The primary duty of a lawyer under the CPR engaged in the public prosecution is not to convict, but to see that justice is done. The suppression of facts or the concealment of witnesses capable of establishing the innocence of the accused is highly reprehensible and is cause for disciplinary action. A lawyer in the government service shall not use his public position to promote or advance his private interest, nor allow the latter to interfere with his public duties. Under Canon 2 of the new Code on Professional Responsibility and Accountability, regarding propriety, Section 31 provides that in the prosecution of criminal cases, the primary duty of a public prosecutor is not to convict, but to see that justice is done. Suppressing facts, concealing of, tampering with, or destroying evidence, coaching a witness, or offering false testimony is cause for disciplinary action. We're talking about rule on government lawyers. The obligation of a public prosecutor shall also be imposed upon lawyers in the private practice who are authorized to prosecute under the direct supervision and control of the public prosecutor. Section 28 talks about dignified government service. Lawyers in government service shall observe the standard of conduct under the CIPRA, the Code of Conduct and Ethical Standards for Public Officials and Employees, and other related laws and issuances in the performance of their duties. Any violation of the CIPRA by lawyers in government service shall be subject to disciplinary action separate and distinct from liability and under pertinent laws or rules. Section 30 provides that no financial interest in transactions, no gifts, a lawyer in government shall not directly or indirectly promote or advance his or her private or financial interest or that of another in any transaction requiring the approval of his or her office. Neither shall such lawyer solicit gifts or receive anything of value in relation to such interest. Such lawyer in government shall not give anything of value to or otherwise unduly favor any person transacting with his or her office with the expectation of any benefit or return. Does the Supreme Court have jurisdiction over complaints filed against government lawyers? In Guevara Castel versus Trinidad, administrative case number 10294, July 12, 2020, the court bank laid down the following guidelines in the filing and handling of complaints against government lawyers. Number one, all complaints against and which seek to discipline government lawyers in their respective capacities as members of the bar must be filed directly before this court. Conversely, complaints which do not seek the discipline as members of the bar shall be dismissed for lack of jurisdiction, referred to the ombudsman or concerned government agencies for appropriate action. In connection with the immediately preceding paragraph, upon filing, the court must determine whether the concerned agency, the ombudsman or the court, has jurisdiction over the complaint against the government lawyer. In making such determination, the following must be observed and considered. Did the allegations of malfeasance touch upon the errant lawyer's continuing obligations under the CIPRA and or the lawyer's oath? To put it more simply, the primordial question to be asked in making the determination is this: do the allegations in the complaint, assuming them to be true, make the lawyer unfit to practice the profession? If the question in paragraph 2, which we just cited, yields a positive answer, the case properly lies before the court, which shall retain jurisdiction. It is so because, again, the power to regulate the practice of law and or discipline members of the bar belongs to the Supreme Court. Necessarily, proceedings to be had before this court shall concern this and only these matters. This rule shall hold even if the complaint also contains allegations of administrative and or civil service rules infractions. In such situation, the court shall limit its ruling only to the matter of respondent's fitness as a lawyer. On the other hand, if the question in paragraph 2 yields a negative answer, the court for lack of jurisdiction shall dismiss the case and refer the same to the appropriate government office or the ombudsman. If multiple complaints have been filed, the process shall be the same. In the event that paragraph 2b, which we mentioned earlier, and results in a situation where one or more complaints have been dismissed and referred to the appropriate government office or the ombudsman, and one or more complaints have been retained by this court, cases shall proceed independently of one another. We now proceed to the Code of Professional Responsibility. What are the duties and responsibilities of a lawyer? The duties and responsibilities of a lawyer are enumerated in the Rules of Court and in the CIPRA. which are, under the rules of court, the following are the duties of the lawyer. Under the CPR, the fourfold duties of the lawyer are also as follows. So we have to defend the accused of a crime, regardless of his personal opinion, to maintain allegiance to the Republic of the Philippines and support the Constitution and obey the laws, to never reject the case of the defenseless or oppressed. And under E is to counsel or maintain such actions, proceedings only as appears to him to be just, and such defense only as he believes to be honestly debatable under the law. To abstain from all offensive personality, and to advance no fact prejudicial to the honor or reputation of the party or witness. Among others, is to observe, maintain the respect due to the court and judicial officers, to employ such means only as are consistent with truth and honor. Never to seek to mislead the judge by any artifice or false statement or fact or law. Under the CPR, the fourfold duties of the lawyers as follows: duties to society in general, duties to the profession, duty to the court, duties to the clients, under Canons 14 to 22. The lawyer's duty to obey the laws and promote respect for the law and legal processes, negatively put, demands that he shall not engage in unlawful, dishonest, immoral, or deceitful conduct. An unlawful conduct is an act or omission which is against the law. This dishonest conduct is an act of lying or cheating, and an immoral or deceitful conduct is one that involves moral turpitude. And the lawyer who engaged in unlawful, dishonest, immoral, or deceitful conduct may be held administratively liable therefore. Needless to state that, again, Justice Hernando in Parch versus Vitorillo, administrative case number 10897, January 4, 2022, said that one's admission to the bar is by no means a license to gloss over the loopholes in legislation, to hijack the legal process, or to manipulate the technical decisions of those unlearned in law. Among the sworn obligations of attorneys upon taking the lawyer's oath is to uphold the Constitution and obey the laws of the land at all times, never to waver, even if vices of luxury, convenience, and worldly excesses tempt them so. There is again my distinction between what the previous Code of Professional Responsibility and now the Code of Professional Responsibility and Accountability have been quite different. Canon 1 under the Code of Professional Responsibility says that the lawyer shall uphold the Constitution, obey the laws of the land, and promote respect for law and legal processes. Rule 1.01 under the CPR says that the lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. And Canon 7 says that the lawyer shall at all times uphold the integrity and dignity of the legal profession and support the activities of the integrated bar. Under the new CPRA, Canon 12 on propriety talks about the lawyer shall at all times act with propriety and maintain the appearance of propriety in personal and professional dealings, observe honesty, respect, and courtesy, and uphold the dignity of the legal profession consistent with the high standards of ethical behavior. Section 1 talks about proper conduct. A lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. And number 2, on dignified conduct, a lawyer shall respect the law and everything which the law mandates him to do. What is the violation of the notarial rules constituting violation of Rule 1.01. In Hermoso versus Parado, administrative case number 8116, September 16, 2020, in the realm of legal ethics, a breach of the aforementioned provisions of the 2004 rules on notarial practice would also constitute a violation of the rules on professional responsibility. Examples of unlawful, dishonest, immoral, or deceitful conduct. In Turla versus Caringal, again, Justice Hernando, in administrative case number 11641, March 12, 2019, posits and says that falsely asserting that he had an exemption from the MCLE requirement. And when Attorney Caringal indicated that he was an MCLE exempt in the pleadings and motions he filed, although in fact he was not, he engaged in dishonest conduct, which was also disrespectful of the courts. He undoubtedly placed his clients at risk, given that pleadings with such false information produce no legal effect and can result in the expunction of the same. Undeniably, he did not stay true to the cause of his clients and actually violated his duty to serve his clients with competence and diligence. Examples of this would be issuance of a worthless check. In Andaya versus Tuwanda, again, Justice Fernando's ruling in AC number 12209, February 18, 2020. It indicates the lawyer's unfitness for the trust and confidence reposed upon him and his lack of personal honesty and good moral character, rendering him unworthy of public confidence. Again, in Cancino, which we mentioned, versus Sideriosa, Justice Hernando, in administrative case number 8522, October 6, 2020, said that engaging in law practice during his suspension and performing his duties as a notary public despite the revocation of his commission constitutes violation of the Code of Professional Conduct and Accountability. Violation of the rules of notarial practice, for example, again, Justice Hernando in Kainer versus Amores, administrative case number 9417, November 18, 2020. He said that violation of the rules of notarial practice and where respondent notarized a document without the presence of a signatory and failed to indicate his commission number in the notarial certificate is a violation of the CIPRA. Number 5, praying and manipulating the child victim to not attend the hearing of the case in PKF versus Palugna. To merit the ultimate penalty of disbarment, the conduct must be grossly immoral. In Arsiga versus Maniwang, 193 Philippines, 730 to 738, 1981. A lawyer may be disbarred for, quote, grossly immoral conduct or by reason of his conviction of a crime involving moral turpitude, close quote. A member of the bar should have moral integrity in addition to professional probity. In Perez versus Katindig, I know the respondent very well here, good friend of mine, but he was disbarred anyway. Immoral conduct involves acts that are willful, flagrant, or shameless, and that show a moral indifference to the option of the upright and respectable members of the community. Immoral conduct is gross when it is so corrupt as to constitute a criminal act or so unprincipled as to be reprehensible to a high degree, or when committed under such scandalous or revolting circumstances as to shock the community's sense of decency. The court makes these distinctions as the supreme penalty of disbarment arising from conduct requires grossly immoral, not simply immoral conduct. In Arriaga versus Maniwang, the court enumerated the following instances where a lawyer was disbarred for grossly immoral conduct. Where lawyer Arturo P. Lopez succeeded in having carnal knowledge of Virginia C. Almirez under promise of marriage, which he refused to fulfill, although they had already a marriage license, and despite the birth of a child in consequence of their sexual intercourse. He married another woman, and during Virginia's pregnancy, Lopez urged her to take pills to hasten the flow of her menstruation, and he tried to convince her to have an abortion, which she did not agree. Almirez versus Lopez, administrative case number 481, February 28, 1969. It's also in 27 SCRA 169. Also, citing Sarmiento versus Queen, 100 Philippines 1102. The case of Cabrera versus Agustin, 106 Philippines 256, where lawyer Francisco Agustin made Anita Cabrera believe that they were married before Leon Agubat in the City Hall of Manila. And after such parents, they cohabited and she later gave birth to the child. Again, it's a grossly immoral conduct. In Toledo versus Toledo, 117 Philippines 768, where lawyer Jesus Toledo abandoned his lawful wife and cohabited with another woman who has borne him a child. As to disbarment for contacting a bigamous marriage, we have to say Villa Santa versus Peralta, 101 Philippines 313. Bolivar versus Symbol, 123 Philippines 450, demonstrates that the conduct of Abelardo Symbol in making the dupe of Concepcion Bolivar by living on her bounty and allowing her to spend for his schooling and other personal necessities, which, while dangling before her the mirage of a marriage, marrying another girl as soon as he had finished his studies, keeping his marriage a secret while continuing to demand money from the complainant, and trying to espouse on her and persuade her to resume their broken relationship after the latter's discovery of his perfidy, are indicative of a character not worthy of a member of the bar. In the case of Kingwa versus Puno, administrative case number 389, February 28, 1967, where Flora Kingwa, a public school teacher who was engaged to lawyer Armando Puno, was prevailed upon by him to have sexual congress with him inside the hotel by telling her that it was all right to have sexual intercourse because anyway, they were going to be married. She used to give Puno money upon his request. After she became pregnant and gave birth to the baby, Attorney Puno refused to marry her. The case of Mortel versus Aspiras, 100 Philippines 586, where lawyer Anacrito Aspiras, a married man, misrepresenting that he was single and making a promise of marriage, succeeded in having sexual intercourse with Josefina Mortel. Aspiras faked a marriage between Josefina and his own son, Cesar. Aspiras wrote to Josefina, "You are alone in my life till the end of my years in the world. I will bring you along with me before the altar of matrimony." Through thick and thin, for better or for worse, in life or in death, my Josephine will always be the first, middle, and last in my life. Spoken like a grossly immoral lawyer, Attorney Aspiras. In Royong versus Oblena, 117 Philippines 805, when lawyer Ariston Oblena, who had been having adulterous relations for 15 years with Brixia Angeles, a married woman separated from her husband, seduced her 18-year-old niece who became pregnant and begot a child. Under the new CIPRA, the misconduct is grossly inexcusable, shameful, or flagrantly unlawful. The same constitutes a serious offense that is punishable by disbarment. Suspension from the practice of law for a period exceeding 6 months, revocation of the notarial commission, disqualification as notary public for not less than 2 years, and a fine exceeding not exceeding 100,000 pesos. Cohabitation per se, according to certain jurisprudence, is not immoral. Whether a lawyer's sexual congress with a woman, not his wife, or without the benefit of marriage should be characterized as an immoral conduct would depend on the surrounding circumstances. Arsiga versus Maniwang. Intimacy between a man and a woman who are not married, especially in light of the circumstances attending the case, is neither so corrupt as to constitute a criminal act nor so unprincipled as to warrant disbarment or disciplinary action against the man as a member of the bar. Neither must we overlook the circumstances that, in view of the facts adverted to above, the others revealed by the record, which for obvious reasons did not be set forth in this decision. It was rather difficult for respondent to marry complainant Karin. Case of Soberano versus Villanueva. 116 Philippines, pages 1208 to 1213, 1962. The duty not to counsel illegal activities. Under Rule 102, Rule 1.02 of the CPR, a lawyer shall not counsel or abet activities aimed at defiance of the law or lessening confidence in the legal system. Example, in Verano versus Tayag, allowing the witness to draft his own judicial affidavit without the supervision of a lawyer. Administrative case number 12612, November 18, 2021. Another example is the selling real properties to aliens despite the prohibition against foreign ownership of Philippine private lands and preparing documents with illegal considerations like pactum commissorium stipulations. The duty to encourage amicable settlements and prohibition against frivolous suits. The useful function of a lawyer is not only to conduct litigation, but also to avoid litigation where possible by advising the settlement or withholding suit. A lawyer should be a mediator for concord and a conciliator for compromise rather than an instigator of controversy and a predator of conflict. Under the previous CPR, Rule 1.03, says that a lawyer shall not for any corrupt motive or interest encourage any suit or proceeding or delay any man's cause. Under the new CIPRA, Section 7 says that the prohibition against frivolous suits and abuse of court processes and cautions the lawyer not to file or encourage the filing of any suit or proceeding not authorized by law or jurisprudence and without any evidentiary support. Number 2, not to unduly impede the execution of an order or judgment which is warranted. Number 3, abuse of court processes. Section 8 of the new CIPRA says that a lawyer shall encourage the client to avoid, end, or settle a controversy, whether pending or not, in order to reach a settlement or a compromise if the matter can be compromised under the law and will admit of a fair settlement. To this end, the lawyer shall actively assist the parties and the court, tribunal, and or government agency to effect mediation and or dispute resolution. Comparably, in Canon 12 of the previous CPR, a lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. Rule 1203 of the CPR says that the lawyer shall not, after obtaining extensions of time to file pleadings, memoranda, or briefs, let the period lapse without submitting the same or offering an explanation for his failure to do so. Rule 12.04 says a lawyer shall not unduly delay a case, impede the execution of a judgment, or misuse court processes. What is barratry? What is ambulance chasing? Barratry is the offense of frequently inciting and stirring up quarrels and suits. In Alcantara versus De Vera, 650 Philippines, pages 2112 to 224, 2010. While maintenance is the intermeddling of an interested party to encourage a lawsuit. Ambulance chasing refers to the solicitation of almost any kind of business by an attorney, personally or through an agent, in order to gain employment. Valencia versus Linsangan, administrative case number 10557, July 10, 2018. What about making legal services available? Canon 2 requires that legal services should not only be efficient, but also be made available and accessible to those who need them in a manner compatible with the ethics of the profession. In addition, a lawyer shall not reject the cause of the defenseless, even in those instances in which he may not, for valid reasons, accept the case. The lawyer shall not refuse to render legal advice to the person concerned, if only to the extent necessary to safeguard the latter's right. Another comparison is Canon 2 of the CPR, which says that the lawyer shall make his legal services available in an efficient and convenient manner compatible with the independence, integrity, and effectiveness of a member of the bar. And in CPRA, it says that independent, accessible, efficient, and effective legal service shall make legal services accessible in an efficient and effective manner. In performing this duty, a lawyer shall maintain independence, act with integrity, and at all times efficiency. What are the instances when a lawyer may decline employment? What are the instances when a lawyer may decline employment? A lawyer should decline professional employment in the following cases. If there exists a conflict of interest. Number 2, if he or she is not in a position to carry out the work effectively or competently. Number 3, if his or her acceptance would constitute a violation of the rules of the legal profession. Number 4, if it involves advocacy in a matter upon the merits of which he has previously acted in a judicial capacity. Number 5, in any matter in which he knows or has reason to believe that he may be an essential witness for the prospective client. Santiago versus Rafanan. Is solicitation of legal business prescribed? In Can Jr. versus Simbilio, 456 Philippines, pages 560 to 568 of 2003, the Supreme Court had occasion to state that the solicitation of a legal business is not altogether prescribed. However, for solicitation to be proper, it must be compatible with the dignity of the legal profession. If it is made in a modest and decorous manner, it would bring no injury to the lawyer and to the bar. Thus, the use of simple signs stating the names of the lawyers, the office and residence of address, and fields of practice, as well as advertisements in legal periodicals bearing the same brief data, are permissible. Even the use of calling cards is now acceptable. Publication in reputable law lists in a manner consistent with the standards of conduct imposed by the canon. A brief biographical and informative data is likewise allowable. What are some of the instances where you try to be within the ambit of true, honest, fair, dignified object information on legal services? Canon 3 says that a lawyer in making known his legal services shall use only true, honest, fair, dignified, and objective information or statement of facts. Rule 3.01 says that a lawyer shall not use or permit the use of any false, fraudulent, misleading, deceptive, undignified, self-laudatory, or unfair statement or claim regarding his qualification or legal services. Rule 3.02 says that in the choice of a firm name, no false, misleading, or assumed name shall be used. The continued use of the name of a deceased partner is permissible, provided that the firm indicates in all its communication that said partner is deceased. Rule 3.03 states that when a partner accepts public office, he shall withdraw from the firm and his name shall be dropped from the firm name unless the law allows him to practice law concurrently. Rule 3.04 states that a lawyer shall not pay or give anything of value to representatives of the mass media in anticipation of or in return for publicly to attract legal business. Duty to participate in and to keep abreast of legal developments. While the lawyer's task is in contributing to the improvement of the legal system will not be a matter of strict duty. This is duty, nevertheless, that flows from the lawyer's sense of public responsibility. Even the objectives of the Integrated of the Philippines definitively says that. The improvement of the legal system cannot, however, be done in a vacuum. The lawyer must recognize that the law is a party of vast social network, and whether he likes it or not, he has to interact with the rest of society. Thus, the need on the part of the lawyer to transcend the narrow limits of technical law. A lawyer must broaden out and continue to grow in knowledge and competence in order to be able to make the law socially responsive. Unless lawyers faithfully comply with Canon 5 of the Canons of Professional Responsibility, he or she may not be able to completely and diligently discharge his or her duties as lawyers. Worse, he or she is susceptible to mistake. Canon 4 under the CPR says that the lawyer shall participate in the development of the legal system by initiating or supporting efforts in law reform and in the improvement of the administration of justice. Canon 5 talks about a lawyer to keep abreast of legal developments, participate in continuing legal education and practice. Canon 3 under the CIPRA talks about fidelity, active involvement in legal education. A lawyer shall keep abreast of legal developments, participate in continuing legal education, and support efforts to achieve the standards of excellence in law schools as well as in the practical training of law students. In addition, a lawyer shall assist the Integrated Bar of the Philippines, the law schools, law alumni associations, law associations, or civic organizations in educating the public on the law and jurisprudence. The IBP chapters under this canon shall provide supervising lawyers to the legal aid clinics in their jurisdictions. What about lawyers' relation with other lawyers? Membership in the bar imposes upon lawyers certain obligations to one another. These include observance of honorable, candid, and courteous dealings with other lawyers, fidelity to known and recognized customs and practices of the bar that make the practice of a law profession. The rule on lawyer's language. As a rule, a lawyer's language, though forceful and emphatic, must always be dignified and respectful, befitting the dignity of the legal profession. The use of intemperate language and unkind ascriptions has no place in the dignity of judicial forum. Under the CPR, Canon 8 talks about a lawyer shall conduct himself with courtesy, fairness, and candor towards his professional colleagues and shall avoid harassing tactics against opposing counsel. Under Canon 2 of propriety under the CPRA, a lawyer shall use only dignified, gender, fair, child, and culturally sensitive language in all personal and professional undertakings. To this end, a lawyer shall not use language which is abusive, intemperate, offensive, or otherwise improper, oral or written, and whether made through traditional or electronic means, including all forms or types of mass or social media. Under Section 34, subsection M of the CPRA, use of intemperate or offensive language before any court, tribunal, or any government agencies, a less serious offense punishable by suspension from the practice of law for a period within range of 1 month to 6 months, or revocation of the notarial commission and disqualification as notary public for less than 2 years, and the fine within the range of 35,000 to 100,000. While the use of vulgar or offensive language in personal dealings is a light offense under Section 35, subsection B, and is punishable by either a fine within the range of 1,000 to 35,000 or censure or reprimand. Comparably, you have Rule 8.01, which says that a lawyer shall not, in his professional dealings, use language which is abusive, offensive, or otherwise. Under Rule 7.03, it says that the lawyer shall not engage in conduct that adversely reflects on the fitness to practice law, nor shall he, whether in public or private life, behave in a scandalous manner to the discredit of the legal profession. Canon 11 also states that the lawyer should observe and maintain the respect due to the courts and to the judicial officers, and should insist on similar conduct by others. Rule 11.03 states that the lawyer shall abstain from scandalous, offensive, or menacing language or behavior before the courts. Sample violations of Rule 8.01 of the CPR. In Fortes versus Santos, administrative case number 13149, September 19, 2020, statements like, quote, complainant induced his clients to extort money, quote, and, quote, is already lasting for attorney's fees. Number 2, in Parks versus Misa Jr., administrative case number 11639, February 5, 2020, statements made in the counter affidavit that Rosaline was known as drug addict, fraud, and making insinuations that her marriage was a fixed marriage were pointless and uncalled for, and thus only shows that the clear intention of Attorney Misa was to humiliate and insult Rosaline. In Celudo versus Finisa, respondent called the complainant an Indian, ascribing discourteous and unsupported imputations not only against the complainant and his counsel, but also against the IBP board. In Fernandez versus Dino Jr., administrative case number 13365, September 27, 2022. What about responsible use of media? Under the CPRA, a lawyer shall uphold the dignity of the legal profession in all social media interactions in a manner that enhances the people's confidence in the legal system, as well as to promote its responsible use. The online posts of lawyers should uphold the dignity of the legal profession and shield it from disrepute. Section 37, it says, and 40, it says that lawyers shall not knowingly or maliciously post, share, or upload false or unverified statements or commit any other act of disinformation. He or she is prohibited from disclosing privileged information through online posts and from communicating, whether directly or indirectly, with an officer of any court, tribunal, or government agency to influence the latter's performance of official duties. It bears stressing that even before the effectivity of the CIPRA, lawyers who committed misconduct via social media are still found guilty of violation of the Code of Professional Responsibility under Rule 8.01, among others. In Belo Henares versus Guevara, respondent in a series of Facebook posts insulted and verbally abused complainant, Dr. Belo Henares, calling her Becky Bello, quack doctor, and stating that she's out to get poetic justice. Respondent further posted boycott Bello, flawless, reckless, Bella essentials. In its ruling, the court reminded us that the freedom of speech and expression, like all constitutional freedoms, is not absolute. It may not be availed of to broadcast lies or half-truths, insult others, destroy their name or reputation, or bring them into disrepute. Accordingly, the court found respondent guilty of violating Rule 8.1, among others, and suspended him from the practice of law for a period of 1 year. In Velasco versus Causing, respondent in his Facebook page made a defamatory post against the opposing party in a nullity of marriage case. Worse, he directly messaged via Facebook the minor son of the opposing party and told him, "Huwag mo gagayahin ng iyong ama." Worse, he shared pictures of complainant's petition in the nullity case, which was still pending before the court. In an attempt to avoid administrative liability, respondent cited Bible verses and argued that he was merely exercising his constitutional right to press freedom. In calling the complainant polygamous, criminal, dishonest, arrogant, disgusting, and a cheater in the subject post, the court found respondent guilty of violating Rule 8.1, among others. The court elucidated that a lawyer is not allowed to divide his personality as an attorney at one time and a mere citizen at another, regardless of whether a lawyer is representing his client, acting as a supposed spokesperson outside of it, or is merely practicing his right to press freedom as a journalist blogger. His duties to the society and his ethical obligations as a member of the bar remains unchanged. Administrative case number 13521 regarding resolution dated January 4, 2022 in administrative matter number 21-12-05, April 18, 2023. The court disbarred attorney Larry Gadon for the viral video clip where he repeatedly cursed and uttered profane, misogynistic, sexist, and abusive remarks against journalist Raisa Robles. A lawyer shall not encroach upon business of another. A lawyer should not steal the other lawyer's client, nor induce the latter to retain him by a promise of better service, good result, or reduced fees for his services. Neither should he disparage another make comparisons, or publicize his talents as a means to feather his law practice. It is, however, the right of a lawyer, without the fear or favor, to give advice in those seeking relief against unfaithful or neglectful counsel. He may properly accept employment to handle a matter which has been previously handled by another lawyer, provided that the other lawyer has been given notice by the client his services have been terminated. Another comparison you have is Rule 80.02. A lawyer shall not directly or indirectly encroach upon the professional employment of another lawyer. However, it is the right of any lawyer, without fear or favor, to assist a person where the other lawyer has been given notice of the termination. In Canon 2 of the CIPRA, Section 24, encroaching or interfering in another lawyer's engagement, a lawyer shall not directly or indirectly encroach upon or interfere in the professional engagement of another lawyer. To whom the lawyers owe their first duty. It is essential that lawyers bear in mind at all times that their first duty is not to their clients, but rather to the courts. That they are above all officers of the court, sworn to assist the courts in rendering services to all and sundry, and only secondarily are they advocates of the exclusive interest of their clients. For this reason, he is required to swear to no falsehood nor consent to the doing of any in court. Chavez versus Viola, 273 Philippines, pages 206 to 12, 1999. Again, another comparison. In Canon 12 of the CPR, a lawyer owes candor, fairness, and good faith to the court. Rule 10.01, a lawyer shall not do any falsehood or consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. Under the CIPRA, Canon 12 of Propriety, Section 11, a lawyer shall not make false representations or statements. A lawyer shall be liable for any material damage caused by such false representations or statements. Under the CPR, Rule 10.02, a lawyer shall not knowingly misquote or misrepresent the contents of a paper, the language or argument of opposing counsel, or the text of a decision or authority, or knowingly cite as law a provision already rendered inoperative by a repeal or amendment, or assert as a fact that which has not been proved. Rule 10.03 says that a lawyer shall observe the rules of procedure and shall not misuse them to defeat the ends of justice. Comparably, in CIPRA, it says that the lawyer shall not, in demand letters or other similar correspondence, make false representations or statements, or impute civil, criminal, or administrative liability without factual or legal basis. A lawyer shall correct false or inaccurate statements and information made in relation to an application for admission to the bar, any pleading, or any other document required by or submitted to the court, tribunal, or agency, as soon as its falsity or inaccuracy is discovered or made known to him or her. Section 12 refers to the duty to report dishonest, deceitful, and misleading conduct. A lawyer shall immediately inform a court, tribunal, or other government agency of any dishonest, deceitful, or misleading conduct related to a matter being handled by said lawyer before such court, tribunal, or any government agency. In Casareo versus De La Cruz, administrative case number 9355, March 15, 2022, respondent failed to inform the Court of Appeals of the fact of his client's death within the period required under the rules. Worse, he filed an unauthorized pleading. The subject motion and ostensibly made it appear that the client was still alive at the time of its filing. By his conduct, Attorney De La Cruz violated Canon 10, Rule 10.01 and 10.03. A lawyer shall not misuse the rules of procedure. Procedural rules are instruments in the speedy administration of justice. They should be used to achieve such end and shall not derail it. Thus, the filing by the lawyer of multiple petitions regarding the same subject matter constitutes abuse of the court's processes and improper conduct that tends to obstruct and degrade the administration of justice. In Chua versus De Castro, 773 Philippines, pages 517 to 523, 2015. Respondent, through atrocious maneuvers, successfully delayed the disposition of the case, causing injury and prejudice to complainant. In doing so, respondent violated his oath of office and the CPR. In Diaz versus Madagan, administrative case number 12669, June 28, 2021, Mandagan, the court stated that respondent, as a member of the bar, should have employed only such means as are consistent with laws, legal processes, truth, and honor. Owing candor, fairness, and good faith to the court, she should have not prosecuted her patently frivolous and meritless complaint or instituted a clearly groundless action before the ombudsman. Being a member of the bar, respondent should have known better not to misuse legal processes to defeat the ends of justice. Observing and maintaining respect due to courts and judicial officers. In the CPR, Canon 11 talks about the lawyer observing and maintaining the respect due to the courts and to judicial officers and should insist on similar conduct by others. Under Rule 11.01, a lawyer shall appear in court properly attired. In CIPRA, under Canon 12, Canon 2, Propriety, Section 7, Formal decorum and appearance. A lawyer shall observe formal decorum before courts, tribunals, and other government agencies. A lawyer's attire shall be consistent with the dignity of the court, tribunal, or other government agency with due respect to the person's sexual orientation, gender identity, and gender expression. The subjudicial rule. A lawyer shall not use any forum or medium to comment or publicize opinion pertaining to a pending proceeding before any court, tribunal, or other government agencies. That may, if the grounds are stated, etc., or impute improper motives against any of its members. Competence and diligence under Canon 4, Section 3, diligence and punctuality. A lawyer shall diligently and seasonably act in any legal matter entrusted by a client. A lawyer shall be punctual in all appearances, submission of pleadings and documents before any court, tribunal, or other government agency, and all matters professionally referred to by the client, including meetings and other commitments. In the CPR, you have Rule 11.02, where a lawyer shall punctually appear at court hearings. Rule 11.03 says that the lawyer shall abstain from scandalous, offensive, or menacing language or behavior before the courts. Rule 11.04, a lawyer shall not attribute to a judge motives not supported by the record or have no materiality to the case. 11.05, a lawyer shall submit grievance against the judge to the proper authorities only. What is the proper attire in courts? Per Office of the Court Administrator Circular number 150-2018, the appropriate office attire as follows: skits of office uniforms, skirts of office uniforms, or casual office attire should be at least knee length. 1 inch above the knee may be allowed. Appropriate footwear and mean closed formal shoes. However, mules, slingback shoes, and prep tools are allowed. Pit tools are allowed. In turn, the following attires are prohibited when performing visual functions: dozy, transparent, or net-like blouse or shirt, sando, sleeveless, strapless, or spaghetti strap blouse, tank tops, unless worn as an undershirt, blouse with ever-plunging necklines, collarless t-shirts for men, micro mini skirt, walking shorts, cycling shorts, leggings, tights, jogging pants, pedal pushers, sandals and step-ins exposing the toes, and rubber sandals, slippers, and bakya, sporting of an unkempt hair, as well as wearing of earrings and other body ornaments by male employees are not allowed. Lawyers should be punctual. A lawyer should show respect due the court and the judicial officer by appearing during a trial of a case punctually and in proper attire. Inexcusable absence from or repeated tardiness in attending a pre-trial or hearing may not only subject the lawyer to disciplinary action, but may also prejudice his client, who, as a consequence thereof, may be non-suited, declared in default, or adjudged liable ex parte. A lawyer shall not attribute to a judge improper motive. People versus Taneo, 348 Philippines, pages 277 to 302, 1998. Attorneys should observe and maintain respect due to courts of justice and judicial officers. Arguments, whether written or oral, should be gracious to both the court and the opposing counsel and be of such words as may be properly addressed by one gentleman to another. The duty of the bar to support the judge against unjust criticism does not, however, preclude the lawyer from filing administrative complaints against erring judges or from acting as counsel for clients who have legitimate grievances against them. However, Rule 11.05 of the CPR reminds that a lawyer shall submit grievances against a judge to the proper authorities only, which means that they be filed with the Supreme Court, which has administrative supervision over all courts and the power to discipline them. Part of legal ethics would be to assist the court in speedy and efficient administration of justice. In the CPR, Canon 12 says that the lawyers exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. In the CIPRA, you have Canon 3 on fidelity, responsibility, and accountable lawyer. As an officer of the court, a lawyer shall uphold the rule of law and conscientiously assist in the speedy and efficient administration of justice. On competence and diligence, you have Canon 2 again, propriety, instituting multiple cases, forum shopping. A lawyer shall not knowingly engage or through gross negligence in forum shopping, which offends against the administration of justice and is a falsehood foisted upon the court, tribunal, or in other government agency. A lawyer shall not institute or advise the client to institute multiple cases to gain leverage in the case, to harass a party, or to delay the proceedings, or to increase the cost of litigation. While in the former CPR, you had 12.02, which says that a lawyer shall not file multiple actions arising from the same case. A lawyer should come to court adequately prepared. Rule 12.01 provides that a lawyer shall not appear for trial unless he has adequately prepared himself and on the law and the facts of this case. The evidence he will adduce and the order which profits. He should also be ready with the original documents for comparison with the copies. Turn. Rules 18.01, 18.02, and 18.03 states that the lawyer shall not undertake a legal service which he knows or should know that he is not qualified to render. He or she should not handle any legal matter without adequate preparation. He or she shall not neglect a legal matter entrusted to him or her unless a lawyer comes to court adequately prepared. The trial may be postponed, which would entail delay in the early disposition of the case. In Go versus Teruel, Justice Hernando, administrative case number 11119, November 4, 2020, Justice Hernando had occasion to say that it is a well-settled rule that the essence of forum shopping is the filing of multiple suits involving the same parties for the same cause of action, either simultaneously or successively, for the purpose of obtaining a favorable judgment. It exists when, as a result of an adverse opinion in one forum, a party seeks a favorable opinion in another, or when he institutes two or more actions or proceedings grounded on the same cause to increase the chances of obtaining a favorable decision. An important factor in determining its existence is the vexation caused to the courts and the parties litigant by filing of similar cases to claim substantially the same reliefs. Forum shopping exists where the elements of litis pendentia are present, or where a final judgment in one case will amount to res judicata in another. Simply put, the outcome of the case would necessarily have an effect to the other, since both cases share the same cause of action and involve the same parties. In Villanueva versus Alintahan, administrative case number 12161, June 8, 2020. Again, Justice Hernando states that there is forum shopping when elements of litis pendentia are present, or where a final judgment in one case will amount to res judicata in another. They are as follows. 1, identity of parties, or at least such parties that represent the same interest in both actions. 2, identity of rights or causes of action. And 3, identity of reliefs sought. I deemed it wise to enumerate these particular rules to emphasize the responsibilities of lawyers, the ethical responsibilities and accountabilities. Rule 1203. A lawyer shall not, after obtaining extensions of time to file pleadings, memoranda, or briefs, let the period lapse without submitting the same or offering an explanation for a failure to do so. Rule 1204.04. A lawyer shall not unduly delay a case, impede the execution of a judgment, or misuse court process. Rule 12.05. A lawyer shall refrain from talking to his witness during a break or recess in the trial while the witness is still under examination. Rule 1206. A lawyer shall not knowingly assist a witness to misrepresent himself or to impersonate another. Rule 1207. A lawyer shall not abuse, browbeat, or harass a witness, nor needlessly inconvenience him. Rule 1208. A lawyer shall avoid testifying in behalf of his client except on formal matters such as mailing, authentication, or custody of an instrument, or on substantial matters in cases where his testimony is essential to the ends of justice, in which event he must, during his testimony, entrust the trial of the case to another counsel. A lawyer shall not delay nor impede the execution of judgment. A lawyer shall not file multiple actions arising from the same case, seeking substantially the same relief as those that had already been disposed of in a final judgment. As an officer of the court whose primary function is to assist the court administer impartial justice, a lawyer should use those rules for the purpose and not for its frustration. A lawyer shall not talk to a witness during recess. The purpose of this is to avoid any suspicion that he is coaching the witness what to say during the resumption of the examination. What are the elements of subornation of perjury? In U.S. versus Paliena, 18 Philippines, pages 382 to 386, 1911, there are certain well-defined and indispensable requisites that must be established in every case of alleged subornation of perjury before an accused person charged with the commission of the crime can be convicted. Every essential element constituting the crime of perjury must be established by competent testimony. The prosecution must show the nature of the proceedings in which the alleged perjury was committed, the court or officer or offer in which or before whom the false oath was taken, that the witness was duly sworn, that the testimony was material and false, the defendant knowingly and willfully procured another to swear falsely, and that the witness suborned did testify under circumstances rendering him guilty of perjury. What are the acts of impropriety that tends to influence the court? Canon 13, a lawyer shall rely upon the merits of his case and refrain from any impropriety which tends to influence or gives the appearance of influencing the court. Rule 1301, a lawyer shall not extend extraordinary attention or hospitality to or seek opportunity for cultivating familiarity with judges. Rule 1302, a lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. Rule 1303, a lawyer shall not brook or invite interference by another branch or agency of the government in the normal course of judicial proceedings. What is the subjudice rule? A lawyer shall rely on the merits of his cause and refrain from making any impropriety which tends to influence or gives the appearance of influencing the court. Improper acts which give the appearance of influencing the court, that is, extending extraordinary attention or hospitality to judges, should be avoided. The subjudice rule restricts comments and disclosures pertaining to the judicial proceedings in order to avoid prejudging this issue, influencing the court, or obstructing the administration of justice. A violation of this rule may render one liable for indirect contempt under Section 3, subsection D, Rule 71 of the Rules of Court, which reads, Section 3, indirect contempt to be punished after charge and hearing. A person guilty of any of the following acts may be punished for indirect contempt, which includes any improper conduct tending or directly or indirectly to impede, to obstruct, or degrade the administration of justice. Under the CIPRA, violation of the subjudice rule, Section 19, Canon 2 is now a less serious offense. What is called the open justice principle? In Re Makasay, 583 Philippines, pages 391 to 487, 2008, the freedom to question the government has been a protected right of long-standing tradition throughout American history. There is no doubt that the fundamental freedom to criticize government necessarily includes the right to criticize the courts, their proceedings and decisions. Since the drafting of the Constitution over 200 years ago, American judges have anticipated and sometimes even encouraged public scrutiny of themselves, if not of the judiciary as a whole. This open justice principle, which is as fundamental to a democratic society as freedom of speech, has been an accepted doctrine in several jurisdictions. It is justified on the ground that if the determination of justice cannot be hidden from the public, this will provide a safeguard against judicial arbitrariness or idiosyncrasy and the maintenance of the public's confidence in the administration of justice. The right of a lawyer to comment on a pending litigation or to impugn the impartiality of a judge to decide is much circumscribed. The court in the pending litigation must be shielded from embarrassment and influence in its all-important duty of deciding a case. It must therefore insist on being permitted to dispose of its business in an orderly manner, free from outside interference, obstructive of its function, and tending to embarrass the administration of justice. On the other hand, once the litigation is concluded, the judge who decided it is subject to the same criticism as any other public official. Being a matter, by the way, of course, court record, which has been taken up at the hearing held publicly and settled in a decision already promulgated, said theory was open for public consumption, and hence an allusion thereto or statement thereof in order to justify said criticism is not actionable. Case of Strebel versus Figueras, 96 Philippines, pages 321 to 335, 1954. When does an attorney-client relationship arise? A lawyer-client relationship is established when a lawyer voluntarily entertains a consultation, regardless of the close relationship between the parties or the absence of a written contract or non-payment of legal fees. Case of Season versus Dumlao, administrative case number 11959, April 28, 2021. The attorney-client relationship continues until the lawyer's authority to represent the interests of the client is sooner revoked or withdrawn by the client. Case of Tolentino versus Mangapit, 209 Philippines, pages 607 to 612, 1983. A comparison again between the CPR and the CIPRA. The CPR, a lawyer-client relationship, begins the time the seeking may be for consultation on transactions or other legal concerns or for representation of a client in an actual case in the court or other fora. Justice Hernando in the case of Constantino versus Aranzazo Jr., which we mentioned earlier. In CIPRA, Section 3 says that the lawyer-client relationship is of the highest fiduciary character. As a trust relation, it is essential that the engagement is founded on the confidence reposed by the client on the lawyer. Therefore, a lawyer-client relationship arises when they're conscious, voluntary, and in good faith, and such providing legal advice, whether expressly or impliedly. The primary task of a lawyer as an advocate is to represent a party litigant in court, either as counsel for plaintiff or for the defendant, or as public prosecutor or as defense counsel. Except for a public prosecutor who cannot choose cases to prosecute, a private practitioner as a rule is not obligated to act as counsel for any person who may wish to become his client. The rule, however, is subject to limitations of Canon 14 of the Court of the Canons of Professional Responsibility. A lawyer shall not refuse his services to the needy under Canon 14. Rule 1401 says that a lawyer shall not decline to represent a client solely on account of the latter's race, sex, creed, or status of life, or because of his own opinion regarding the guilt of said person. Rule 1402, 14.02, a lawyer shall not decline, except for serious and sufficient cause, an appointment as counsel de oficio or as amicus curiae, or a request from the Integrated Bar of the Philippines or any of its chapters for rendition of free legal aid. Rule 1403, a lawyer may not refuse to accept representation of an indigent client unless he is not in a position to carry out the work effectively or competently. He labors under a conflict of interest between him and the prospective client, or between the present client and the prospective client. And Rule 1404 says that the lawyer who accepts the cost of a person unable to pay his professional fees shall observe the same standard of conduct governing his relations with paying clients. There are two reasons for the rule. First, the poor and the needy are the persons who, when in trouble, need most the services of a lawyer, but hesitate to secure such services because they cannot afford to pay counsel's fees or fear they will be refused for their inability to compensate the lawyer. Second, one of the objectives of the IBP is to make legal services fully available for those who need them. And the fulfillment of this objective requires that the lawyer should not lightly decline employment for the poor and the needy. Who is an amicus curiae? It's a Latin which means friend of the court, refers to an experienced and impartial attorney who may be invited by the court to appear to help in the disposition of issues submitted to it under Rule 138, Section 36. Who is an indigent client? An indigent client is one whose gross income and that of his immediate family do not exceed an amount double the monthly minimum wage of an employee, and who does not own real property with the fair market value as stated in the current tax declaration of more than 300,000. Other rules would include Canon 15. A lawyer shall observe candor, fairness, and loyalty in all his dealings and transactions with his client. Rule 1501. A lawyer, in conferring with a prospective client, shall ascertain as soon as possible or practicable whether the matter would involve a conflict with another client or his own interest, and if so, shall forthwith inform the prospective client. Rule 1502. A lawyer shall be bound by the rule on privileged communication in respect of matters disclosed to him by a prospective client. Rule 1503. A lawyer shall not represent conflicting interests except by the written consent of all concerned, given all the full disclosure of the facts. Rule 1504. A lawyer may, with the written consent of all concerned, act as mediator, conciliator, or arbitrator in settling disputes. A lawyer shall ascertain possible conflict of interest. It is the duty of a lawyer to disclose and explain to a prospective client all circumstances of his relations to the parties and any interest in or connection with the controversy which in his honest judgment might influence the client in the selection of counsel. The disclosure is more or less or more for the protection of the lawyer than that of the client. If, for instance, a lawyer conceals the fact that the adverse party used to be his client, the new client might have a reason to suspect, in case of unfavorable judgment, that the circumstance prevented him from the full discharge of his duties. A lawyer shall preserve the secrets of prospective clients. In Legazpi versus Gonzalez, administrative case number 12076, June 22, 2020. Matters disclosed by a prospective client to a lawyer are protected by the rule on privileged communication, even if the prospective client does not thereafter retain the lawyer or the latter declines the employment. The reason for this rule is to make the prospective client free to discuss whatever he wishes with the lawyer without fear that what he tells the lawyer will be disavowed, false, or used against him, and for the lawyer to be equally free to obtain information from the prospective client. This is also overly emphasized in the revised rules, the new revised rules on evidence. Further, under Sabitsana Jr. versus Vertige, 716 Philippines, 1 pages 1 to 19, 2013. The termination of an attorney-client relation provides no justification for a lawyer to represent an interest adverse to or conflict with that of the former client on a matter involving confidential information which the lawyer acquired when he was counsel. The client's confidence, once imposed, should not be divested by mere expiration of professional employment. In Parungao versus Lacuanan, a lawyer's duty to protect the interest and confidence of his client, together with the corollary obligation not to represent interest in conflict or inconsistent with the same, extends beyond the end of his professional engagement with said client. The protection given to the client is perpetual and does not cease with the termination of the litigation, nor is it affected by the parties ceasing to employ the attorney and retaining another, or by any other change of relation between them. It even survives the death of the client, according to the ponencia of Justice Fernando in Parungao versus Lacuanan, March 11, 2020, administrative case number 12071. The purpose of the attorney-client privilege is encapsulated in Ang versus Marapao, administrative case number 10297, March 9, 2022. It is his duty of an attorney to maintain inviolate the confidence and at every peril to himself or yourself, to preserve the secret of his or her client. The performance of such duty involves the application of rules of evidence and of professional ethics, both of which seek to safeguard the client's confidence. To adequately represent a client, a full disclosure of the facts by the client to his attorney is a must, unless the client knows that his attorney cannot be compelled to reveal what is told to him. He will suppress what he thinks or still thinks to be unfavorable facts. If that happens, then the legal advice will be useless, if not misleading. Lawsuits will be conducted along improper lines, and trials will be full of surprises. The purpose of the attorney-client privilege is to encourage a client to make full disclosure to his or her attorney and to place unrestricted confidence in the attorney in matters affecting the client's rights or obligations. What are the factors that must be established for the rule on privileged communication between an attorney and his or her client to apply? The factors essential to establish the existence of the privilege are as follows, according to Mercado versus Vitriolo, 498 Philippines, pages 49 to 61, 2005. The factors. Number one, there exists an attorney-client relationship or prospective attorney-client relationship. It is by this reason of this relationship that the client made the communication. Number two, the client made the communication in confidence. And number three, the legal advice must be sought from the attorney in his professional capacity. Again, Justice Fernando in Parungao versus Lacuanan says that under Canon 21 of the CTR, quote, a lawyer shall preserve the confidences and secrets of his client even after the attorney-client privileges or relation is terminated. It is settled that the mere relation of attorney and client does not raise a presumption of confidentiality. Proof must be presented that the client intended that the communication must be confidential. What are the exceptions to the privilege? Rule 21.01. A lawyer shall not reveal the confidences or secrets of his client except, number one, when authorized by the client after acquainting him of the consequences of the disclosure. Number two, when required by law, certainly. Number three, when necessary to collect his fees or to defend himself, his employees, or associates by judicial action. Who are the persons covered by attorney-client privilege? The following persons are covered, and its lawyer, the client, persons reasonably believed to be by the client to be licensed to engage in the practice of law in the rules of evidence, and third persons who by reason of their work have acquired information about the case being handled as such. For example, secretaries, stenographers, messengers, and agents. A lawyer shall not represent conflicting interests. There is a conflict of interest when a lawyer represents himself inconsistent interests of two or more opposing parties. The test is whether or not, on behalf of one client, it is the lawyer's duty to fight for an issue or claim, but it is his duty to oppose it for the other client. In brief, if he argues for one client, the argument will be opposed by him when he argues for the other client. This rule covers not only cases in which confidential communications have been confided, but also those in which no confidence has been bestowed or will be used. Also, there is a conflict of interest if the acceptance of the new retainer will require the attorney to perform an act which will injuriously affect his first client in any matter in which he represents him, and also whether he will be called upon in his new relation to use against his first client any knowledge acquired through their connection. Another test of the inconsistency of interest is whether the acceptance of a new relation will prevent an attorney from full discharge of his duty of undivided fidelity and loyalty to his client, or invite suspicion of unfaithfulness or double dealing in the performance thereof. Simply put, in determining whether a lawyer is guilty of violating the rules on conflict of interest under the CTR, it is essential to determine whether the conflicting duties test the lawyer's duty bound to fight for an issue or claim in behalf of the client and at the same time oppose the claim of the other client. Number two, the invitation of suspicion duty, the acceptance of a new relation will prevent full discharge of a lawyer's duty of undivided fidelity and loyalty to the client, or invite suspicion of unfaithfulness or double dealing in the performance of that. And the use of prior knowledge test, which a lawyer would be called upon in a new relation to use against a former client any confidential information acquired through the connection or previous employment. Again, Justice Hernando and Administrative Matter Number 8111, December 9, 2020, Villamor versus Humawas. Rule 15.05. A lawyer, when advising his client, shall give a candid and honest opinion on the merits and probable results of the client's case, neither overstating nor understanding the prospects of the case. Rule 1506. A lawyer shall not state or imply that he is able to influence any public official, tribunal, or legislative body. Canon 13 says that a lawyer shall rely upon the merits of his cause and refrain from any impropriety which tends to influence or gives the appearance of influence in the court. The other rules will include Rule 15.07. A lawyer shall impress upon his client compliance with the laws and principles of fairness. Canon 19 says that the lawyer shall represent his client with zeal within the bounds of the law. Rule 19.01, a lawyer shall employ only fair and honest means to attain the lawful objectives of his client and shall not participate in presenting or threaten to present unfounded criminal case charges to obtain an improper advantage in any case or proceeding. Rule 19.02, a lawyer who has received information that his client has, in the course of his representation, perpetrated a fraud upon person or tribunal, shall promptly call upon the client to rectify the same, and failing which he shall terminate the relationship with such client in accordance with the rules of court. Rule 19.03, a lawyer shall not allow his client to dictate the procedure in handling the case. Rule 1508, a lawyer who is engaged in another profession or occupation concurrently with the practice of law shall make clear to his client whether he is acting as a lawyer or in another capacity. These are 3 cases on influence pending. In Fajardo versus Alvarez, 785 Philippines, 303 to 334, 2016. A lawyer who approaches a judge to try to gain influence and receive a favorable outcome for his or her client violates Canon 13 of the Code of Professional Responsibility. This act of influence peddling is highly immoral and has no place in the legal profession. In Jimenez versus Verano Jr., administrative case number 8108, 10299, July 15, 2014. In Sylvia Santos versus Judge Evelyn S. Arcaya-Chua, the court saw fit to impose a 6-month suspension against a judge who likewise committed acts of influence pending when she solicited 100,000 from complainant Santos when the latter asked for her help in the case of her friend Emerita Munoz, who had a pending case with the Supreme Court because the respondent judge was a former court attorney of the High Court. In Dumlao Jr. versus Camacho, administrative case number 10498, September 4, 2018. By implying that he can influence the Supreme Court justices to advocate his cause, respondent trampled upon the integrity of the judicial system and eroded confidence in the judiciary. The gross disrespect of the judicial system shows this wanting in moral fiber, that he lacks integrity in his character. His acts of respondent constitute the height of arrogance and deceit. Respondent violated Canon 13, Rule 13.01, Canon and Canon 10.01 of the Professional Ethics Code. What is the prohibition on private individuals when dealing with public officials? The Anti-Graft and Corrupt Practices Act, Section 4, subsection A, says that it shall be unlawful for any person having family or close personal relations with any public official to capitalize or exploit or take advantage of such family or close personal relationship by directly or indirectly requesting or receiving any present, gift, material, or pecuniary advantage from any other person having some business transaction application, request or contract with the government in which such public official has to intervene. Family relations shall include the spouse or relatives by consanguinity or affinity in the 3rd civil degree. The word close personal relations shall include close personal friendship, social and fraternal connections, and professional employment, all giving rise to intimacy which assures free access to public officers. A lawyer shall impress upon his client compliance with the laws and principles of fairness. Case number 1, Tolentino versus Attorney So Anancheta, 790 Philippines, pages 252 to 266, 2016. The lawyer promised his clients that there will still be a remedy against the adverse Supreme Court, against the Court of Appeals decision, and asked them to part with the amount of 200,000 purported to be used for making arrangement with the justices of the Court of Appeals before whom the case was pending. Ruling. As a servant of the law, Attorney Ancheta's primary duty was to obey the laws and promote respect for the law and the legal processes. Corollary to this duty is his obligation to abstain from dishonesty or deceitful conduct, as well as from activities aimed at defiance of the law or at lessening confidence in the legal system. Attorney Ancheta's advice involving corruption of judicial officers trumps the integrity and dignity of the legal profession and the judicial system and adversely reflects on his fitness to practice law. Case number 2, Philippine Islands Kids International Foundation Incorporated versus Palugna, administrative case number 11-11653, November 22, 2021. Lawyer counsel of the accused in the rape case met with the minor rape victim and asked her not to attend the hearing of the in exchange for payment. The lawyer then hired the victim's minor boyfriend as a security guard in a remote area and offered him a weekly salary, provided that he would bring the minor rape victim with him. Consequently, the rape victim failed to attend the hearings of the case until she was rescued by the police authorities. Ruling. Attorney Palugna is disbarred. Attorney Palugna owes good faith, fairness, and candor to the court. While he is given the liberty to defend his client's cause with utmost zeal, this obligation, however, is not without reasonable limitations. His responsibility to protect and advance the interests of his client must not be pursued at the expense of the truth and the administration of justice. To iterate, this is not the only instance where Attorney Palugna used this scheme to suppress the truth and defeat the ends of justice. In another criminal case filed against Collins, the child victim therein asserted that she was unable to attend the court hearings in her case because Attorney Palugna sent her to Davao to avoid the case. In Jimeno Jr. versus Jimeno, which we have mentioned already, lawyer forged the signature of her deceased relatives and sold their property. Attorney Jimeno is suspended for 6 months. A respondent asks in relation to the subject special power of attorney and the subject deed constitutes blatant transgression of their duties as a lawyer, as ordained by Rule 1.01 of Canon 1 of the CPR, which engraves an overriding prohibition against any form of misconduct. Additionally, the court finds that respondent fell short of her duty to impress upon her client compliance with the pertinent laws in relation to the subject transaction. The highly fiduciary nature of an attorney-client relationship imposes upon the lawyer the duty to account for the money received from his or her client. A lawyer's failure to return upon demand the money he or she received from his or her client gives rise to the presumption that he or she has appropriated the same for he or his or her own use. In Francia versus Sagario, administrative case number 10938, October 8, 2019. Again, penned by Justice Hernando. Lawyer's lien, lawyer cannot unilaterally appropriate his client's property. While the CIPRA sanctions an attorney's lien over the funds and papers of the client, jurisprudence dictates that the lawyer claiming the same must be able to establish the following elements. 1, the existence of a lawyer-client relationship. Number 2, there must be lawful possession of the client's funds, documents, and papers. And there is an unsatisfied claim for attorney's fees. Here, the case is Spouses San Pedro versus Mendoza, 749 Philippines, 540 to 550, 2014. Again, a decision penned by Justice Fernando in Home Guarantee Corporation versus Taguyana, administrative case number 13131, February 23, 2022. Respondents then claimed that they were merely exercising their right to withhold, to exercise retaining lien for unpaid fees. The court, however, finds that the requisites to exercise lien were not met and discussed it is essential that the client consent to the application of its property to the unpaid fees because a lawyer cannot unilaterally appropriate his client's property. Here, there is no proof that Home Guarantee Corporation consented to the respondent's withholding of the titles to satisfy the unpaid legal fees. Thus, the court finds the respondent improperly exercised his right to retain Home Guarantee Corporation's documents as lien. Another comparison, we have Canon 16. A lawyer shall hold in trust all monies and properties of his client that may come into his possession. Rule 16.01, a lawyer shall account for all money or property collected or received to or from the client. Rule 1602, a lawyer shall keep the funds of each client separate, apart from his own and those of others kept by him. In the new provisions on the CIPRA, Canon 3 talks about Section 49, where a lawyer, during the existence of the lawyer-client relationship, shall account for and prepare an inventory of any fund or property belonging to the client, whether received from the latter or from the third person immediately upon such receipt. When funds are entrusted to a lawyer by a client for a specific purpose, the lawyer shall use such funds only for the client's declared purpose. Any unused amount of the entrusted funds shall be promptly returned to the client upon accomplishment of the stated purpose of the client's demand. In Section 56, a lawyer who is discharged from or terminated from his engagement shall submit to an attorney's lien. Immediately render a full account of and turn over all documents, evidence, funds, and properties belonging to the client. Lawyers, either in person or through another, are prohibited from acquiring the properties and rights in litigation. Article 1491, subparagraph 5 of the Civil Code reads, the following persons cannot acquire by purchase, even at public or judicial auction, either in person or through the mediation of another, includes justices, judges, prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with the administration of justice, the property and rights in litigation or levied upon on execution before the courts within whose jurisdiction or territory they exercise their respective function. This prohibition includes the act of acquiring by assignment and shall apply to lawyers with respect to the property and rights which may be the object of any litigation in which they may take part by virtue of their profession. The rational advance for the prohibition is that public policy disallows the transactions in view of the fiduciary relationship involved, the relation of trust and confidence, and the peculiar control exercised by these persons. It is founded on public policy because by virtue of his office, an attorney may easily take advantage of the credulity and ignorance of his client and unduly enrich himself at the expense of his client. For the prohibition to apply, the foregoing elements must be established. Again, attorney-client relationship, property or interest of the client must be in litigation. The attorney takes part as counsel in the case. The attorney himself or through another purchases the property or interest during the pendency of the litigation. Does the practice of law require exactissima diligencia? The practice of law does not require extraordinary diligence or that extreme measure of care and caution which persons of unusual prudence and circumspection use for securing and preserving their rights. All that is required is ordinary diligence, diligencia, or the degree of vigilance expected of the bonus pater familias, exemplified by Edquebal versus Ferrer Jr. 491 Philippines, pages 1 to 8, 2005. What is the rule with regards to mistakes committed by lawyers? As a general rule, a client is bound by the mistakes of his counsel. Velasquez versus Court of Appeals, 368 Philippines, 863, pages 863 to 870, 1999. Only when the application of the general rule would result in serious injustice should an exception there to be called for. Villaricar Bas versus De La Cruz, 241 Philippines, pages 14 to 19, 1988. What are the exceptions? We have previously allowed the relaxation of these rigid rules of procedure in order to serve substantial justice in considering matters of life, liberty, honor, or property, the existence of special or compelling circumstances, the merits of the case, a cause not entirely attributable to the fault of negligence of the party favored by the suspension of the rules, a lack of any showing that the review sought is merely frivolous and dilatory, or the party will not be unjustly prejudiced thereby. These are contained in the case of Mega Fishing Corporation versus Estate of Gonzales, GR number 214781, March 9, 2022. Again, penned by Justice Hernando. Client must be kept informed of the status of the case. In Portuguese versus Centro, administrative case number 12875, January 26, 2021. Ponente, Justice Hernando again. Facts. Respondent was complainant's counsel in a civil case pending before the RTC. At the termination of the proceedings, the parties were required to file their memoranda. Respondent informed complainant that the memorandum was already filed in court. However, respondent did not actually file any memorandum. Hence, a decision was rendered against complainant in 2017, which was received by the respondent. Then in 2018, complainant and his family were served by sheriff to copy of a notice, giving them 3 days to comply with the writ of execution in connection with the civil case. Apparently, this was the first time that the complainant learned of a rendition of a judgment in the same case. Ruling, the court suspended respondent from the practice of law for 3 years. Attorney Centro's unjustifiable negligence and abandonment of his client's cause violated the lawyer's oath as well as the CPR. He casually set aside the legal matter that was entrusted to him, of which deserved his full attention and diligence. He was grossly negligent of his duty as counsel and was manifestly disinterested in his client's cause. He must be reminded that as a lawyer, he is duty-bound to serve his client with competence and to attend to his client's cause with diligence, care, and devotion. This is because a lawyer owes fidelity to his client's cause and must always be mindful of the trust and confidence reposed on him. What is the doctrine of imputed knowledge as applied to lawyer-client relationships? In the case of De Leon versus Manufacturers Life Insurance Company Philippines, Incorporated, GR number 24373, January 12, 2021, Under the doctrine of imputed knowledge, notice to the agent is deemed notice to the principal. As applied to lawyer-client relationship, it means that the knowledge of any fact that is acquired by a lawyer during the existence of the relationship and while acting within the scope of his authority is imputed to the client. The exceptions to the doctrine of imputed knowledge are as follows. Number one, if strict application might foster dangerous collusion to the detriment of justice. Number two, service of notice of one party instead of upon his authority is ordered by the court. And three, notice of pre-trial is required to be served upon the parties and their respective lawyers. As an officer of the court, a lawyer shall uphold the Constitution, obey the laws of the land, and promote respect for law and legal processes. A lawyer should not render any service or give advice to any client which will involve defiance of the laws which he is bound to uphold and obey. Lim versus Bautista, administrative case number 13468, February 21, 2023. In Regala versus Sandigan Bayan, 330 Philippines, pages 678 to 755, 1996. Under our jurisdiction, lawyers are mandated not to counsel or abate activities aimed at defiance of the law or at lessening confidence in the legal system. A lawyer shall charge only fair and reasonable fees. Rule 20.01. A lawyer shall be guided by the following factors in determining his fees: the time spent and the extent of services rendered or required, the novelty and difficulty of the questions involved, the importance of the subject matter, the skills demanded, the probability of losing other employment as a result of acceptance of the preferred case, the customary charges for similar services, and the schedule of fees at the IBP chapter to which they belongs, the amount involved in the controversy and the benefits resulting to the client from the service, the contingency or certainty of compensation, the character of the employment, whether occasional or established, and the professional standing of the lawyer. Rule 20.02. A lawyer shall, in case of referral, with the consent of the client, be entitled to a division of fees in proportion to the work performed and responsibility assumed. Rule 20.03. A lawyer shall not, without the full knowledge and consent of the client, accept any fee, reward, costs, commission, interest, rebate, or forwarding allowance or other compensation whatsoever related to his professional employment from anyone other than the client. Rule 20.04. Lawyers shall avoid controversies with clients concerning his compensation and shall resort to judicial action only to prevent imposition, injustice, or fraud. What are the requisites to be entitled to attorney's fees? As a rule, the right of a lawyer to reasonable compensation for services is subject to two requisites. One, the existence of an attorney-client relationship, the rendition of the lawyer of services to the clients. That's a lawyer who does not render legal services is not entitled to attorney's fees. Otherwise, not only would he be unjustly enriched at the expense of the client, he would also be rewarded for his negligence and irresponsibility. Case of Villesa versus Macosa, 611 Philippines 179-193 2009. A stipulation on the lawyer's compensation in a written contract for professional services is binding. However, this is not an absolute rule. A lawyer is first and foremost an officer of the court. As such, he participates in the fundamental function of administering justice in society. It follows that a lawyer's compensation for professional services rendered is subject to the supervision of the court. and just to guarantee that the fees he charges or receives remain reasonable, commensurate with the service rendered, but also to maintain the dignity and integrity of the legal profession to which they belong, which we discussed in Bihag versus ERA earlier. If the court finds in the same case that the stipulated fees are unreasonable or unconscionable, it may accordingly reduce it or fix a reasonable amount taking into consideration surrounding circumstances and established parameters. Quantum merit in Rosario Jr. versus De Guzman, GR number 191247, July 10, 2013, 703 Philippines 6782-692. Quantum merit, literally meaning as much as he deserves, is used as the basis for determining an attorney's professional fees in the absence of an express agreement. The recovery of an attorney's fees on the basis of quantum merit is a device that prevents an unscrupulous client from running away with the fruits of the legal services of counsel without paying for it. And it also avoids unjust enrichment on the part of the attorney itself. An attorney must show that he is entitled to reasonable compensation for the effort in pursuing the client's cause, taking into account certain factors in fixing the amount of legal fees. In Traders Royal Bank Employees Union Independent versus National Labor Relations Commission, GR number 120592, March 1497, there is a distinction between a general retainer and a special retainer. A general retainer or retaining fee is the fee paid to a lawyer to secure his future services as general counsel for any ordinary legal problem that may arise in the routinary business of the client and referred to him for legal action. The future services of the lawyer are secured and committed to the retaining client. For this, the client pays the lawyer a fixed retainer fee, which could be monthly or otherwise, depending upon their arrangement. The fees are paid whether or not there are cases referred to the lawyer. The reason for the remuneration is that the lawyer is deprived of the opportunity of rendering services for a fee to the opposing party or other parties. In fine, it is compensation for lost opportunities. A special retainer is a fee for a specific case handled or special services rendered by a lawyer for a client. A client may have several cases demanding special or individual attention. If for every case there is a separate and independent contract for attorney's fees, each fee is considered a special retainer. Distinction between general or retaining and special or charging lien. A retaining lien is a passive lien, while a charging lien is an active lien. A retaining lien covers only the client's funds, properties, papers in the lawful possession of the lawyer by reason of a professional employment, while a charging lien covers all judgment for the payment of money and execution issued in pursuance of such judgment. In a retaining lien, it is notice to client, notice to client is not needed, while in a charging lien, notice must be served upon the client and the adverse party. In retaining lien, it may be exercised before judgment or execution or regardless thereof, while the charging lien is a final money judgment in favor of the counsel's client is significant so that charging of attorney's fees may commence. A lawyer shall preserve the confidence and secrets of his client after attorney-client relation is terminated. A lawyer shall preserve the confidence and secrets of his clients even after the attorney-client relation terminated. A lawyer shall not reveal confidences or secrets of the client except as we already enumerated early on. A lawyer shall withdraw his services only for good cause and upon appropriate notice in the circumstances. Section 26, Rule 138 says that an attorney may retire at any time from any action or special proceeding by the written consent of his client filed in court. He may also retire at any time from an action or proceeding without the consent of the client should the court on notice to the client and attorney and on hearing determine that he ought to be allowed to retire. In case of substitution, the name of the attorney newly employed shall be entered in the docket in place of the former one, and a written notice of the change shall be given to the adverse party. A lawyer shall withdraw his services only for good cause and upon notice appropriate in the circumstances. Rule 22.01. A lawyer may withdraw his services in any of the following cases: when the client pursues an illegal or immoral course of conduct in connection with the matter he is handling. Second, when the client insists that the lawyer pursue conduct violative of these canons and rules. Number three, when his inability to work with co-counsel will not promote the best interest of the client. Number four, when the mental or physical condition of the lawyer renders it difficult for him to carry out the employment effectively. Number five is when the client deliberately fails to pay the fees for the service or fails to comply with the retainership agreement. What are the duties of the lawyer in case of the death of a party? Under Section 16 of the Rules of Court, the counsel has the duty to, Rule 3, counsel has the duty to inform the court within 30 days after the death of his or her client of the fact of the name and address of the deceased legal representatives. Failure to do so constitutes a ground for disciplinary action. Significantly, the counsel's duty of informing the court of his or her client's death is the only representation that he or she can perform in such cases, considering that the client's very death forecloses any further lawyer-client relationship between them. Rico versus Salutan in administrative case number 9257, March 5, 2018, talks about the nature of disbarment proceedings. Disciplinary proceedings are sui generis, neither purely civil nor purely criminal. They do not involve a trial of an action or a suit, but is rather an investigation by the court into the conduct of one of its officers, not being intended to inflict punishment. It is in no sense a criminal prosecution. Accordingly, it also involves neither a plaintiff nor a prosecutor. It may be initiated by the court motu proprio, and public interest is its primary objective. And the real question for determination is whether or not the attorney is still a fit person to be allowed the privileges as such. Hence, in the exercise of its disciplinary powers, the court merely calls upon the member of the bar to account for his actuations as an officer of the court with the end and view of preserving the purity of the legal profession and the proper and honest administration of justice by purging the profession of members who by their misconduct have proved themselves no longer worthy to be entrusted with the duties and responsibilities pertaining to the office of an attorney. In such posture, there can thus be no occasion to speak of a complainant or a prosecutors. Every person has the right to be presumed innocent unless the contrary is proved. Considering the gravity of the consequences of the disbarment or suspension of a lawyer, the court has consistently ruled that the lawyer enjoys the presumption of innocence and the burden of proof rests upon the complainant to satisfactorily prove the allegations in his or her complaint through substantial evidence. Time and again, the court has held that mere allegation is not evidence and is not equivalent to proof. Charges based on mere suspicion and speculation cannot be given credence. The case of spouses Nocuenca versus Bensi, Justice Fernando, administrative case number 12609, February 10, 2020. Disbarment is the most severe form of disciplinary sanction, hence it must be exercised with great caution. It must therefore be imposed only for serious reasons and its clear cases of misconduct affecting the standing and moral character of the lawyer as an officer of the court and member of the bar. The real party in interest rule is not applicable in disbarment proceedings. The procedural requirement observed in ordinary civil proceedings that only the real party in interest must initiate the suit does not apply in the disbarment case. In fact, the person who called the attention of the court to a lawyer's misconduct is in no sense a party and generally has no interest in the outcome. Complainant's desistance will not render the case moot. The case of Coronel versus Cunanan, administrative case number 6738. Disciplinary proceedings against the lawyer do not involve private interests, but only how the lawyer conducts himself in his public and private lives. Accordingly, neither the affidavit of desistance nor the joint motion to dismiss should bear any weight or be relevant in determining whether or not the respondent was fit to remain as a member of the law profession. The desistance by the complainant was a matter that was the concern only of the parties and was not binding on the court. There is no double disbarment in our jurisdiction. When the respondent has been previously disbarred and is subsequently found guilty of a new charge, the court may impose a fine or order to the disbarred lawyer to return the money or property to the client when proper. It shall not be imposed, but the penalty shall be recorded in the personal file of the disbarred lawyer in the office of the bar confidant or other office designated for the purpose. In the event that the disbarred lawyer applies for judicial clemency, the penalty so recorded shall be considered in the resolution of the same. What are the grounds for disbarment or suspension? This will include malpractice, deceit, gross misconduct in office, grossly immoral conduct, conviction of a crime involving moral turpitude, violation of a lawyer's oath, willful disobedience of the order of the court, corruptly or willfully appearing as an attorney in a party case without authority to do so. Notarial practice. And this is the administrative matter 02-8-13 Supreme Court. A person commissioned as a notary public may perform notarial acts in any place within the territorial jurisdiction of the commissioning court for a period of 2 years, commencing the first day of January of the year in which the commissioning is made, unless earlier revoked or the notary public has resigned under these rules, the rules of court. What are the powers of the notary public? We have acknowledgements, oath and affirmations, jurats, signature witnessing, copy certification, any other act authorized by these rules. When is a notary public prohibited from performing a notarial act? Under Section 2, Rule 4 of the Notarial Rules, the notary public shall not perform a notarial act outside his regular place of work or business, or if a person involved as signatory or instrument of document at the time of the notarization. Judicial grounds for the revocation of notarial commission and imposition of administrative sanctions before we finally go to a simple discussion of judicial ethics. The grounds would be that the notary public fails to keep a notarial register, fails to make the proper entry in his notarial register, fails to affix to acknowledgements the date of expiration of his commission, knowingly performs or fails to perform any other act prohibited, mandated by the rules, fails to identify a principal on the basis of personal knowledge or competent evidence, fails to require the presence of the principal at the time of the notarial act, fails to make his report within a reasonable time to the executive judge concerning the performance of his duties as may be required by the judge. Now we come to a short discussion which concludes this lecture on the new Code of Judicial Conduct for the Philippine Judiciary. Canon 1 is independence. Judicial independence is a prerequisite to the rule of law and a fundamental guarantee of a fair trial. A judge shall therefore uphold and exemplify judicial independence in both its individual and institutional aspects. Section 1, the judges shall exercise judicial functions independently on the basis of their assessment of the facts and in accordance with the conscientious understanding of the law, free from any extraneous influence, inducement, pressure, threat, or interference, direct or indirect from any quarter or for any reason. Section 2, in performing the judicial duties, judges shall be independent from judicial colleagues in respect of decisions which the judge is obliged to make independently. Section 3, judges shall refrain from influencing in any manner the outcome of litigation or dispute pending before another court or administrative agency. Section 4, judges shall not allow family, social, or other relationships to influence judicial conduct or judgment. The prestige of judicial office shall not be used or lend advice to private interests of others, nor convey or permit others to convey the impression that they are in a special position to influence the judge. The other sections talks about the judges exhibiting, promoting high standards of judicial conduct in order to enforce public confidence in the judiciary, which is fundamental to the maintenance of judicial independence. Shall be independent in relation to society in general and in relation to particular parties of the dispute of which he has to adjudicate. Judges shall not only be free from inappropriate connections with and influenced by the executive and legislative branches of government, but must also appear to be free from any reasonable observer. Employees of the court have no business meeting with litigants or their representatives under any circumstances. The judge who was included in the president's narcotics on investigation, it was discovered that he would ask for money in exchange for acquittals. In August 15, as the facts are August 7, 2016, President Duterte publicly named 7 judges, including the herein respondent who were allegedly involved in illegal drugs. Upon investigation, the OCA received various affidavits attesting that they were all acquitted of criminal charges against them. Apparently, the corrupt dealings of the respondents well known in the legal circles in Baguio City. The price of acquittals and dismissals of drug cases ranges from 200,000 to 300,000. The alleged modus operandi of respondent judge was that he will prepare 2 decisions, one for acquittal and one for conviction. Norma would then approach the family of the accused to ask for money in exchange for an acquittal. If payment was given on time, the decision for acquittal will be one rendered. If the accused was not able to give the judge the money before the decision was promulgated, the accused will be convicted. However, if the accused files a motion for reconsideration together with the money, the conviction will be reversed and the accused will be acquitted. The court found respondent guilty of gross ignorance of the law, gross misconduct, and violations of canons 1, 2, 3 of the new Code of Judicial Conduct. Accordingly, he is disqualified from re-employment or appointment to any public office, including government-owned or controlled corporations. This is the case of Office of the Court Administrator versus Reyes. Administrative Matter Number RTJ-17-2506, November 10, 2020. In the same case, the ratio decidendi was to the effect, which I quote, and says that the judge is a visible representation of the law and justice. He should be beyond reproach and must conduct himself with the highest integrity. Even a suspicion of illegal dealings concerning the judge loses the public's faith and confidence in the judiciary. The inclusion of respondent judge to the President's narco list is a cause for concern for the judiciary, more so when such allegations are supported by the affidavits of numerous persons and confirmed by the judicial audit and investigation conducted by the Office of the Court Administrator. Canon 2 refers to integrity, essential not only to the proper discharge of the judicial office, but also to the personal demeanor of the judge. There are several sections there. And in the case of the Office of the Administrator versus Atilio Jr., Administrative Matter Number RTJ-21-018, September 29, 2021, the court agrees with the Office of the Court Administrator that Judge Atilio Jr. had breached his duty to avoid impropriety or even just the appearance of impropriety when he posted the subject picture showing his half-dressed body and tattooed torso on his Facebook account that eventually became very readily accessible to the general public. The court clarifies that the impropriety in this case relates solely on Judge Atilio's act of posting the subject pictures on social media, and it has absolutely nothing to do with his choice to have tattoos on his body. Simply put, by posting the pictures on Facebook, Judge Atilio Jr. placed himself in a situation where he and the status he holds as a sitting judge became the object of the public's criticism and ridicule. This is easily evinced by the very fact that an anonymous person saw it fit to send the pictures to the Office of the Court Administrator for appropriate disciplinary action. In Lorenzana versus Austria, Administrative Matter Number RTJ-09-2200, April 2, 2014, it exemplifies the violation of the canon where the respondent judge disregarded the propriety and appearance of propriety required of her when she posted Friendster photos of herself wearing an off-shouldered suggestive dress made this available for public viewing. We are not also aware that the respondent's act of posting her photos would seem harmless and inoffensive had this act been done by an ordinary member of the public. As the visible personification of law and justice, however, judges are held to higher standards of conduct and thus must accordingly comport themselves. The third canon is impartiality, where it is essential to the proper discharge of the judicial office. It applies not only to the decision itself, but also to the process by which the decision is made. Subjudicial rule, again, the court admonished the judge who discussed this case in his class, a case which is still pending before the court. In the case of Tormis versus Paredes, Administrative Matter Number RTJ-13-2366, February 4, 2015, 753 Philippines 41-58. And may I read? The subjudicial rule restricts comments and disclosure pertaining to the judicial proceedings in order to avoid prejudging the issue, influencing the court, or obstructing the administration of justice. The rationale for the rule was spelled out in Nestle Philippines Incorporated versus Sanchez, where it was stated that it is traditional conviction of civilized society everywhere that courts and juries in the decision of issues of facts and law should be immune from every extraneous influence. That facts should be decided upon evidence by producing court, and that the determination of such facts should be uninfluenced by bias, prejudice, or sympathies. Notably, when Judge Paredes discussed the marriage scams involving Judge Stormix in 2010, the investigation related to the said case had not yet been concluded. In fact, the decision on the case was promulgated by the court only on April 2, 2013. In 2010, he still could not make comments on the administrative case to prevent any undue influence in its resolution. Commenting on the marriage scams where Judge Stormix was one of the judges involved was in contravention of the sub judice rule. A judge must not only be impartial, but must also appear to be impartial at all times. Case of Gakad versus Clapis Jr. Administrative matter number RTJ-10-2257, July 17, 2012. The acts of Judge Clapis in meeting Gakad, a litigant in the case pending before his sala, and telling her, sige, kaya ko na bahalang, gamusun natin sila. Okay, leave it to me. We shall crush them. Both favoring Gakad constitute gross misconduct. It is an ironclad principle that the judge must not only be impartial, he must also appear to be impartial at all times. Being in constant scrutiny by the public, his language, both written and spoken, must be guarded and measured lest the best intentions be misconstrued. Needless to state, any gross misconduct seriously undermines the faith and confidence of the people in the judiciary. Allowing a judge to inhibit without concrete proof of personal interest or any showing that his bias stems from an extrajudicial will open floodgates to abuse. In Chavez versus Marcos, GR number 185484, June 27, 2018, the ponencia stated that whether or not to voluntarily inhibit from hearing cases a matter which is within the judge's discretion, absent clear and convincing evidence to overcome the presumption that the judge will dispense justice in accordance with the law and evidence, the court will not interfere. Thus, since the second paragraph of Rule 137, Section 1 was introduced, this court has periodically repeated that it shall always presume that the judge will decide on the merits of the case without bias. Allowing a judge to inhibit without concrete proof of personal interest or any showing this bias stems from an extrajudicial source will open the floodgates to abuse. Canon 4, propriety and appearance of propriety are essential to the performance of the activities of the judge. Boasting of his fraternal ties with the executive department and his disclosure that he has been a judge for the past 20 years is in a complaint protest because his son did not qualify as a member of the national team in a swimming competition constitutes vulgar and unbecoming conduct. In the case of Velasco versus Cordero, Junior, a administrative matter number MTJ 21-202, April 26, 2021, by sending a strongly worded containing threats of using his fraternal influence with members of the executive department, Judge Cordero Jr. gave the impression that judges could resort to extra legal measures, thereby eroding the public's confidence in the judicial system. As a magistrate tasked to uphold the law, he should have been content with resorting to legal measures in order to resolve whatever grievance he had with the PSI, its officers and employees. However, Judge Cordero Jr.'s disclosure that he is a judge and has been with the judiciary for 20 years, coupled with including his title as a judge at the end of his letter, does not automatically render him administratively liable. The circumstances of the instant case do not show that he used his judicial position to advance his private interests. Nevertheless, for failing to be more circumspect in his choice of words and for boosting his alleged fraternal ties with the executive department, this court finds Judge Cordero Jr. guilty of unbecoming conduct. Equality under Canon 5, ensuring equality of treatment to all before the courts is essential to the due performance of judicial office. Homophobic slurs, which have no place in our courts of law. The statements Judge Loredo made during preliminary conference, and especially in the comment he filed in this case, are clearly tantamount to homophobic slurs, which have no place in our courts of law. The fact that they were made by no less than the magistrate himself should rightfully upset the court and must perforce be penalized. It was not long ago when the court in Angladlad, LGBT Party versus Commission of Election declared that as far as this court is concerned, our democracy precludes using the religious or moral values of one part of the community to exclude from consideration the values of other members of the community. Thus, it should come as a matter of course for all judges to desist from any word or conduct that would show or suggest anything other than inclusivity for members of the LGBTQIA+ community. The court, therefore, it is not difficult, according to the court, to imagine the reasons behind the censure, religious beliefs, convictions about preservation of marriage, family, procreation, even dislike or distrust of members of the LGBTQIA+ community and their perceived lifestyle. Thus, whatsoever that these so-called generally accepted public morals have not been convincingly transplanted into the realm of our law, there should be no reason for judges to add to the burdens of the LGBTQIA+ community through swift hand of judicial reviews or to effectively lend the hand in perpetuating the discrimination which the community faces, whether that effort is self-evident or thinly veiled under claims of religious beliefs or freedom of expression. Competence and diligence are requisites to the due performance of judicial office under Canon 6. It is indispensable that judges should act within prescribed period to prevent delay in the speedy disposition of cases. Undue delay, judge did not act on the motion for a period of almost 6 months. Ramiro versus Bignana, AM number RTJ-21-016, September 29 to 2021. Needless to state, judges are mandated to decide cases with dispatch. Thus, plaintiffs had 5 days to file their reply thereto. However, it was not until November 8, 2019, when Judge Buenagoa was convinced that no reply on the comment was coming and finally declared the motion for reconsideration submitted for resolution. As a result of his complacency, no action was apparently taken to the case for almost 6 months. Discipline and administrative jurisdiction over the members of the judiciary. The amended Rule 140 provides for a framework of administrative discipline that, among others, includes a list of administrative offenses with their own nomenclature, classification, and penalties. The amended rule expanded its coverage to govern administrative disciplinary cases against all members, justices and judges, officials, employees, and personnel of the entire judiciary. What is the effect of death, retirement, and separation from service to the proceedings? Disciplinary proceedings may not be instituted against a member, official, employee, or person of the judiciary who has already died, retired, or otherwise separated from service. If such proceedings have been instituted notwithstanding the foregoing circumstances, the administrative case against a member, official, or employee of the judiciary shall be dismissed. So, how are the penalties imposed by the court? If one or more aggravating circumstances and no mitigating circumstances, the Supreme Court may impose the penalties of suspension or fine for a period or amount not exceeding double at the maximum period prescribed under this rule. If there are both aggravating and mitigating circumstances, the Supreme Court may offset each other. If one or more mitigating circumstances and no aggravating circumstances are present, the Supreme Court may impose the penalties of suspension or fine for a period amount not less than half of the minimum prescribed under this rule. That ends. I'm sorry about the lengthy lecture, but in fact, there's still others which might have been considered, but hopefully we may have covered a broad spectrum of legal and judicial ethics for this lecture. Yes.
Thank you po so much, Dean. Would you have a last message po for our baristas to end the Caso Discurso for this year?
You must have noticed that for the baristas, you must notice I mentioned a lot of cases of Justice Hernando, who is the supervising justice now for the coming bar examinations. I don't know if it was tradition before, but apparently most of our bar review centers have been advising us that we should concentrate or exert efforts to cite cases which has been penned by the supervising justice. And hopefully, anyway, whether it's penned by Justice Hernando or other justices, the jurisprudence still remains, and then there are no stupendous or gigantic changes in jurisprudence regarding legal and judicial ethics. Yes.
Thank you po so much, Dean. Thank you for your time. I'm sure our baristas learned a lot from you, and they will bring that until the bar exam. And even
We will also
after.
be giving them the copies of this, and if I get the nod of my partner
Okay.
before the September 4, September 4 lecture. Thank
Okay.
you. Yeah.
Thank you, Dean.
Shall I leave now? Huh? Thank you. You're welcome.
Thank you so much, everyone, for attending. Once again, we would like to thank our sponsors, Rex Bookstore and Central Books. And please make sure to follow the page of the Philippine Association of Law Schools for the upcoming lectures that we have in store for you. Thank you and good night, everyone.